और non-bailable section is 1. Both serious allegation. आप किसी
serious तो that I'm not on the allegation, you're only on the custody. क्योंकि इसमें charge भी frame हो गया है. Charge has been framed.
Charge किसमें frame हुआ? Charge किस section में?
ये तो हमको नहीं पता.
3 साल का punishment है ना, bailable non-bailable इसमें.
हाँ, bailable में है 3 साल.
हम आपको नहीं दे सकते.
That is it.
बहुत serious है.
If you watch it, kindly appreciate.
Very important.
Only watch it.
कोई बात नहीं. आपका trial expedite करा दो.
Sorry.
Charge frame हो गया ना, trial expedite.
Charge तो if you watch it, kindly appreciate.
I am appreciating it.
एक और चीज़ हम बताना चाह रहे हैं. For same incident, you watch it, one more FIR was there. By the cyber police, you watch it. In that particular case, you watch it, I was granted bail. By the same court.
Very good.
That also
दोनों को merge कराइए. We do not know what is the allegation there.
The same allegation have got on record.
अरे भाई उसको merge कराइए, एक को quash कराइए, कुछ कराइएगा ना.
हम क्या बोलना चाह रहे हैं? If you watch it, kindly appreciate one aspect of the matter.
You see, if the high-ups in the society are not safe, it is very serious.
So far as the allegation is concerned, the only thing is that my SIM card was found, from which the post was made. It is not the case that I have created the post. I have shared the post. That is the allegation. The post was shared from my SIM card. That is the allegation. Sorry.
Now you listen to that. I've heard you.
BA
number 3097 of 2026. The learned counsel for the petitioner submits that the petitioner is in custody since
6/9/25.
Since 6/9/25.
More than 7 years.
And he has been falsely implicated in this case, and only SIM was recovered from his possession.
SIM and mobile phone.
And mobile phone was recovered from his possession. He has further submitted that most of the sections are available in nature, and may extend to 3 years maybe. 75.
75/14. I'm talking about 75/14, Your Worship. So was 75.
That's right. We have got it.
One I is.
That's right. The learned counsel has submitted that the maximum punishment which can be imposed under section 75(1)(4) is
1
year. However, during the course of argument, it transpired that so far as other sections are concerned, the prescribed punishments are much higher. The learned counsel for the state has supposed a prayer. यहाँ पे ना हम I don't want to dictate. Page number 30 में allegation है. Considering the seriousness of offence with respect to none less than dash, right? This court is not inclined to enlarge the petition on bail. However, the state is directed that the prosecution witnesses are promptly produced before the court so that the trial is taken to judgment. और बाकी सब combination. To the director prosecution. The learned counsel has submitted that there is another FIR arising out of the same offence. In which the petitioner has been enlarged on bail.
On bail from the session court.
By the sessions court itself. So far as the second FIR is concerned, it is for the petitioner to take appropriate steps in connection with the second FIR. And this bail is to be considered only with respect to the FIR which has been presented before this court.
Some time frame is fixed so far as the trial is concerned.
काफी है. Director prosecution को दे दिया है direction.
Item 7 BA 3101 of 2026.
Yes, Mr. Tiwari. I think for last 5 times or 6 times I have asked you to ensure that the director prosecution comes to the court.
नहीं actually
But आप लोगों को बिना जुडिशियल ऑर्डर के कोई बात न सुनाई देता है न समझ में आता है।
नहीं, आज भी हमारी बात हुई नहीं।
बस बात आप करते रहिए, 5 दिन से यही कहानी चल रहा है।
उनका
एवरी टाइम यू सेड ट्यूसडे मंडे को आएंगे, देन आई सेड नहीं मंडे नहीं पॉसिबल है, ट्यूसडे को आएंगे, राइट? He did not come and you also did not inform me as to why he did not come. Isn't it? Was that not your duty to inform the court as to, because you see you are not understanding what I am saying.
नहीं, हमको आने के लिए हमारी मीटिंग भी हो चुकी है, सारा रिपोर्ट्स भी कलेक्ट हो गया, आज भी हमारी बात हुई है उससे। एक्चुअली वो डॉक्टर के यहाँ है, अभी 11-12 बजे के बाद आएंगे, उसके बाद कम्युनिकेट करेंगे कि फर्दर। आज भी हमारी बात हुई।
हर चीज के लिए जुडिशियल ऑर्डर की जरूरत है।
जुडिशियल ऑर्डर नहीं, उनकी सारी रिपोर्ट मेरे पास आकर पड़ी हुई है। आज उनका अपॉइंटमेंट था, 3 हमारे एक इन्वेस्टिगेशन साइड से आ रहे थे, एक उनको आ रहा था
और एक कौन है उनका सीआईडी में है, बाला क्या नाम है,
नेहा,
उनको लेके
नेहा वाला को भी कम्युनिकेटर कि तीनों एक साथ आएंगे, ताकि यहाँ पे हम उनको समझाएं कि आखिर किस लिए खोल रही है। तो हम लोग प्रोसिक्यूशन और इन्वेस्टिगेशन में आप लोग का जो मैटर है उससे रिलेटेड, तो हमारी जो प्रोसिक्यूशन से
कोई हम लोग देखिए कुछ चीज़ों को समझना चाह रहे हैं, ठीक है? जैसे कि किसी का एलिगेशन होता है कि फ़ोन पर वायरल हुआ, ये हुआ, फ़ोन सीज नहीं होता है, फ़ोन ही सीज नहीं होता। एक तो होता है फ़ोन सीज किए कुछ नहीं मिला, फ़ोन सीज ही नहीं हुआ, कम से कम इतना तो आएगा, डिस्ट्रॉय कर दिया, हटा दिया, कुछ तो आएगा, कोई सीजन नहीं है फोन का।
एक अभी हमारे पास सारे उसके रिपोर्ट्स हैं, हम उसके लिए तैयार हैं, लेकिन चूंकि वो नहीं थे इसलिए हम कुछ नहीं बोल रहे।
नहीं तो ये सारी चीजें हैं व्हिच वी वांट टू।
कोर्ट नंबर 4 में भी कल केस लगा हुआ था, ये इन्वेस्टिगेशन कैसे होता है साइबर के केसेस में, उसी के लिए केस लगा हुआ था कल 4। पूरा एसओपी आया है, पूरा होम मिनिस्ट्री का क्या उसका डायरेक्शन है, स्टेट।
और हम ये जानना चाहते हैं कि जितने भी अलग अलग स्टेट में कंप्लेंट लॉन्च हो रहे हैं, आर दे डिस्टिंक्ट एफआईआरस और दे विल बी कवर्ड बाय द सेम एफआईआर? क्योंकि जब आप बोल रहे हैं उनसे समझना तो होगा ना, तो जब आप एंटीसीडेंट रिपोर्ट देते हैं तो कैसे देते हैं नो क्रिमिनल एंटीसीडेंट? हाउ?
वो बोलते हैं कि एज पर माय आईसीजीएस पोर्टल।
नो
रिपोर्ट
ये कोई बात है क्या? यू आर द प्रोसिक्यूटिंग एजेंसी, मतलब 10 महीना के अंदर 5 कंप्लेंट आ गया और आप उसको एक एफआईआर में क्लब कर दिए and the petitioner has no criminal antecedent. You have to, because each is a distinct offence. अब किस तरह का you should know how to, after all it's a directed prosecution who will give the antecedent report of the person. अब आपका stereotype, वही तो ये सब stereotype चल रहा है।
नहीं, हम दोनों को एक साथ लाना चाह रहे हैं।
लेके आइए ये सारी चीजें, these are matters of concern and we have to find out what is to be done.
मोस्ट प्रोबेबली मंडे को हम लोग लाएंगे।
अच्छा 30 तारीख को सेकेंड हाफ में रहेगा सीबीआई मैटर्स। आई एम जस्ट इन्फॉर्मिंग यू बिकॉज ऑन 38 लॉट ऑफ साइबर क्राइम केसेस आर ऑलरेडी पोस्टेड, सो इन द फर्स्ट हाफ वी विल हैव साइबर क्राइम मैटर्स और जो भी हम लोग का बोर्ड है, एंड सीबीआई मैटर्स एंड पीसी एक्ट मैटर्स विल बी देयर इन द सेकेंड हाफ। ठीक है, यू इन्फॉर्म ऑल द काउंसिल।
उनके सारे रिपोर्ट्स मेरे पास आ गए, आज उनको आना था, आज 12 बजे हमको टाइम उनको,
इट्स ओके,
लेकिन उनको कुछ मेडिकल हमको सुबह आते समय कॉल।
देखिए आई डोंट बिलीव इन कॉलिंग एनी ऑफिसर इन द कोर्ट, बट देयर आर सर्टेन थिंग्स व्हिच आई रियली वांट टू अंडरस्टैंड फ्रॉम देम, बिकॉज व्हाइल गिविंग बेल आई हैव टू बी कॉशियस अबाउट इट, तो वो थोड़ा सा असिस्टेंस का जरूरत है और एक ही बार आना पड़ेगा।
जो बोला गया मैं आप तो उसके पहले ही बोलने के पहले ही हम लोग जरूर समझे थे कि उनकी किसी को हम लोग पड़ेगी इन्वेस्टिगेशन से।
चलिए ठीक है।
Item 7 BA3101 of 2026.
In the case of cyber offense, earlier the matter was withdrawn from the coordinate bench of this court.
Tied up. It's a tied up matter. I will not take it up. Even if it is withdrawn, I have discussed it, and we are of the view that even in a case of withdrawal, it's a tied up matter. Speculation and bench hunting नहीं हो सकता है ना। आज यहाँ पे आया, यू नो दिस कोर्ट विल नॉट गिव यू, विड्रॉ कर लिए, उसका फिर फाइल कर दिया, फिर दूसरा कोर्ट में लग गया। इट हैज टू बी अ टाइड अप मैटर।
Earlier I have argued this matter, but then after
आपने एक केस में टाइड अप कराया है ना, आप ही का तो सेम प्रिंसिपल।
there was after some argument place.
नहीं, we have at least I have decided it's a tied up matter. I will not take it up.
Item 8 BA3108 of 2026.
Earlier rejected matter of
4 witnesses have been examined till 13/5/25.
Yes, sir.
उसके बाद क्या हुआ?
Sir, I have annexed the depositions.
13/5/25 के बाद क्या हुआ? That is the last witness you have annexed.
Sir, development is.
The trial is not. BA number
next week.
not required. Not required. BA number 3108 of 2026. Also, for the parties are present. The bail application of the petitioner was earlier rejected by a coordinate bench of this court in BA number 10671 of 24 by the order dated 13/2/2025. The petitioner has renewed his prayer for bail on the ground of custody since
22nd of June 2020.
22/6/2024. 2024. As per the records, the 4 witnesses were already examined till 13/5/25. The counsel for the petitioner is not aware about the present status. However, the trial is already on, and a few witnesses must have been examined till now. Considering the fact that the bail application was rejected on merits earlier, this court is not inclined to enlarge the petition on bail. However, the state is directed to ensure that the witnesses are promptly produced before the court. The counsel for the state is directed to communicate this order to the SP of the concerned district and also to the directives.
Item 9 BA 3112 of 2026.
Yeah, twice rejected.
Was earlier rejected, Your Lordship.
Yes.
Your Lordship, as per the FIR, the allegation
Earlier
is that,
rejected, what is something new?
Your Lordship, the charge has been framed, some of the witnesses has been examined.
How many witnesses have been
Your
examined?
Lordship, with
How
respect-
many
With
witnesses?
respect to that, I don't have any information, Your Lordship. Only the stage of trial may be called for.
Not required.
Your Lordship, for
You
last
see,
2
when the
years, I have been
case,
custodian.
once the case has been rejected on merits earlier, I can only expedite the trial.
Your Lordship, for last 2 years, I have been custodian.
We will expedite it. And in spite of this order, if they do not come, right, we will consider your bail application and put the SP and the director of prosecution under contempt proceedings.
Your Lordship, stage
We'll do
may be
that.
called for.
Not required. BA number 3112 of 2026. For the learned counsels appearing on behalf of the parties, the learned counsel for the petitioner submits that the bail application of the petitioner was rejected earlier twice.
Your Lordship, once.
Once.
Rejected earlier in BA number 5576 of 2024 by the order dated 23rd of August 2025 and the 24th, the prayer for bail has been rejected on the ground of custody since 17/4/2024. The learned counsel has also submitted that the trial has commenced and the few witnesses have been examined, but she is not aware as to how many witnesses have been examined so far. The learned counsel for the state has opposed the prayer. After hearing the learned counsel for the parties, the bail application of the petitioner having been rejected earlier on merits, this court is not inclined to enlarge the petition on bail. Further, the trial is already in progress. The state is directed to ensure that the witnesses are promptly produced before the court. The counsel for the state is directed to communicate this order to the director of prosecution and also to the SP of the concerned district.
Not one thing. All the co-accused, there are 3 co-accused. Both of them has been granted bail.
Okay.
Only a time frame may be.
It is already there. I am telling you, if the witnesses do not come, you just come again. You annex the entire order sheet.
Yes.
Move on. आप लोग कम्युनिकेट कर रहे हैं ना ठीक से? ऐसा नहीं हो कि वो लोग बोले हमें पता नहीं.
नहीं, जिसमें ऑर्डर होता है डायरेक्शन हम लोग कम्युनिकेट करते हैं.
Item 10 BA 3120 of 2026.
sections around the
Also for the state is
वो एलिगेशन स्पेसिफिक किसी और पे मेरे पे मारने का the lower part of the fire 10 lines from bottom
इंजुरी रिपोर्ट मंगा दी.
हम लोग क्योंकि यूपी ऑर्डर में भी कुछ नहीं लिखा है
इंजुरी रिपोर्ट मंगा.
यस
The learned counsel for the parties are present. The counsel for the state is directed to file counter affidavit. an antecedent report of the petitioner. The case diary be called for from the concerned court along with the injury report of the victims and also the stage of the case.
Pending investigation.
Stage पता आई जाए. Stage आ जाने दीजिए.
Okay, but investigation has not yet been completed.
We'll see.
Yes.
बताइए कौन सा डेट है? First April.
Item 11, DA.17.04.2026.
Pose this case and tag with DA number 2751 of 2026, which is already listed, and post it on 30/4/2026. Also, for the state is directed to file counter affidavit and antecedent report of application.
Under heading for admission, item 12, ABA 7221 of 2025.
In this case, the prayer of the petitioner for grant of anticipated bail, that is 120B, 409 and 420 of the IPC, as well as section 456 of the Price Cheat and Money Circulation Scheme Business Act 1978. In this case, it will also be kindly see after investigation, it was originally filed before the police, local police. Thereafter, it was transferred under the orders of his own court to the CBI. CBI, after investigation, submitted charge sheet. I have annexed the charge sheet as an excerpt to subject to lordship's kind pleasure, page 25 it stars. But your lordship will kindly see the allegation part. There are several active persons, including the present petitioner. Your lordship will kindly come to page number 50. Relevant. This is one of the charges under the heading charges.
Yes.
Investigation, second paragraph. Investigation of the case further revealed Mohammed Nur Alam and other accused directors, shareholders, such and such of the company, Mr. Mohammed Jasim Ansari, he is the petitioner. Rizwan Ansari, such and such. In last of year 2010, the company Web Project Limited became without paying the maturity amount to its investors, and there was a pressure of payment of maturity on the associate agents of Messrs. Web Project Limited and Mohammed Nur Alam, who has been granted regular bail, along with other of the aforesaid agents of such and such, with an intention to deceive such and such. Now, the relevant part note again, I am permitted to refer to page number 54. Page 54. The names of several persons. The investigation of the case revealed Purva Jyoti Vishwas, Vijay Kumar, both agents. Then such and such, Mohammed, yes, last paragraph. Investigation of the case revealed Purva Jyoti Vishwas, Mohammed Jasim Ansari, and Vijay Kumar Bhagat were appointed as the director of the company, Mrs. Radhe Industries Limited. As per the memorandum of association, the main business of the said company is real estate and construction to the company. These apart, there is no specific allegation against the petitioner. The case of the petitioner, the just see page 56. Investigation of the case revealed last paragraph. Mohammed Nur Alam, Mohammed Jasim Ansari, Rizwan Ansari, Mukhtar Ansari, Arvind Kumar Murmu, all active directors, and Amitullah Ansari, such and such. Now, Rizwan Ansari has been granted anticipated bail. I am permitted to place a web copy. And so, when Nur Alam, he was arrested, therefore he was granted regular bail. I also have the copy of the bail order.
Just. Anticipatory bail of Nur Alam was rejected, right?
Yes. He was
granted regular bail.
Regular. I will submit it because
Anticipatory bail of Rizwan Ansari has been allowed.
it was yes by
And
that I have
just a
provided.
moment.
Copy I have provided.
So one anticipatory bail was rejected and another
And another was
anticipatory was
allowed. Now, so for the second, which was anticipated allowed under paragraph 3, in the kindness of that order. Especially paragraph 5. Paragraph 5. In view of the above, it transpires that earlier the petitioner had moved in a deal. His prayer was earlier rejected also, while the matter was being investigated by the state police. And subsequently, the matter was transferred to the CBI pursuant to the order of the High Court, and the CBI has now investigated the matter and submitted the charge sheet. From the charge sheet, it is clear that the petitioner is not shown as an absconder, and that in view of that, it is clear that the petitioner has cooperated in the investigation. Now the charge sheet has already been submitted, and it is further well settled that under the same circumstance, the second entry will be there.
What is the maximum punishment?
In this case, 409 is more than 10 years.
Therefore, that until case does not apply. You see, there is very serious allegation. You are a director of a company who did not have a license.
And the case of this petitioner is stands.
We will see.
And his prayer was rejected
Yes.
when the matter was pending for the state.
That's right.
And thereafter he was granted bail. I have already referred to the charge sheet. And charge sheet does not disclose anything distinguishable feature in respect of this petitioner with the in comparison to Rijwana.
You under your digital signature, everything was happening. You were the persons who were also uploading that form 32 of the company.
No,
Yes.
There are several persons. It is not the case that the petitioner is the person on whose instruction the forms were filled out.
Not a case for anticipatory
The
case.
charge sheet
You
not-
see, a company is entering into, this banking business or financial business. They are required to have a license.
Yes,
It is as good as,
absolutely.
if in layman's language, if I say it is as good as driving a vehicle without a license.
Yes, that is there. But they should be punished. But so far,
Anticipatory bail का conditions बिल्कुल अलग है.
But-
You have to show
but
that you are not.
anticipated bail was granted.
We will see that. We'll see that.
Anticipated
Yes,
bail was
yes.
granted to the similarly situated person.
I will see that. I will
And the
distinguish
charge
it from
sheet does not disclose any difference in the
We'll
facts.
take care of it. Yes.
Lordship, in this case, matter relates to chit fund scam, Lordship. We have already investigated, filed our charge sheet way back in
And read the charge sheet.
Correct.
Yes.
We have already submitted our charge sheet in the year 2017, Lordship. So far, Lordship, the apprehension, there is no apprehension of arrest, Lordship. And in similar matter, Lordship, last week, Lordship, passed an order, Lordship. Lordship, they may surrender in the court, Lordship. In view of para 8, 9, 10, Lordship, have observed, Lordship, that in view of Satyendra until and Siddharth, Lordship. Since there is no apprehension of arrest, they can surrender, Lordship, in the court. It's not a case of anticipatory. This matter, Lordship, also relates to chit fund scam.
आपका ये ऑर्डर चलेगा?
चलेगा जी, एक लाइन से. This is my prayer, utmost prayer. I have submitted that.
वो आपको फेवर कर दिया, आपको तो रिजेक्ट कर.
बहुत अच्छा किया.
बहुत अच्छा.
ये हमको दिखाया होते तो हम उतना अप्रूव करेंगे. शायद नहीं.
चलिए.
तो एक ही prayer मेरा submission.
फेवर नहीं किए, he is fair to you.
Very much. Very much fair to everybody, not to me. He is my
It is arising out of the same affair. Similar order कर देते हैं. एकदम सही to say.
एक ही चीज हम सिर्फ बोलना चाहते हैं. एक चीज हम मेरा submission. कि one of the co-accused, Rijwan Ali, has been granted admission.
That I will.
Your Lordship.
Then I'll have to also say that there is direct allegation. I will say that. फिर हम बहुत चीज बोलेंगे. आपका 10 years भी बोलेंगे. Satyendra until is not applicable वो भी बोलेंगे because then I have to distinguish, no?
Same offense.
Same offense
तो
है तो क्या?
same order कर.
Same order is better. क्योंकि बहुत चीज हम ना ही बोले तो ज्यादा अच्छा. Same order कर.
हम लोग ज्यादा बोल सकते हैं.
देखिए आपके इंटरेस्ट में है कि हम ना.
इसलिए अगर हम अपना इंटरेस्ट के लिए ज्यादा बोले.
क्योंकि 10 years होने से सत्येंद्र इंटेल का कहानी खत्म.
फिल्ट्रेट करके ठीक है.
और आप लोग के पास तो है ही बोलने के लिए. कोर्ट तो तैयार था लेकिन कुछ लिखा देता तो आप एडवर्स हो जाता. तो आप दिखा सकते हैं अपने लिटिगेंट को.
उसके लिए भी हम लोग बोलेंगे.
इसीलिए देखिए आप लोग का कोई भी सबमिशन होता है तो हम ध्यान देते हैं. Because I know that people may view this video People
I
may
was
view
not
this
aware about
video.
this order. Otherwise, at the very outset, I could have.
That should be sufficient. चलिए same order.
Case number.
Case number भी same. Same FIR है ना?
वही भी 967
वहाँ का case number
RC case अलग RC is different
RC case is different.
but matter related to check from
Same everything.
Yes, बताइए।
only RC
RC
there were
case
several
number
cases also
ये पैरा 1 से ले लेंगे. ठीक है? RC केस नंबर चेंज होगा इसका. Right?
Item 13 DA 111822 of 2025.
This case was wanted also. All the counsel of the petitioner reach out of the station since lately reach suffering from pressure and oppression of going to be admitted also. That's why he is not project.
Just a minute.
Monday correctly.
At the request of the counsel for the petitioner, the matter is directed to be listed on Monday.
Yes.
Monday. Item 13 DA 111822 2025.
and no criminal antecedent, एक मोबाइल रिकवरी, one victim is there. Similarly,
Item 14.
yes.
I have received the diary of the morning and
Antecedent है?
नहीं, no criminal antecedent that I have stated, you know.
वेरीफाई कर लेंगे ना, वहाँ रिलीज कर लेंगे
हाँ,
पहले.
yes, yes,
एंटीसीडेंट आ गया तो नहीं रिलीज
नहीं,
करेंगे.
yes.
देखो एंटीसीडेंट का एक पेज में रिपोर्ट हमारे पास भी आया है कि एंटीसीडेंट नहीं
नहीं, तब तो क्लियर हो गया.
Yes.
वन विक्टिम.
Yeah, one victim.
Same similarly.
For the learned counsel से पेरिंग on behalf of the parties. Custody बताइए.
Madam, custody is 12/22/11/2025.
The learned counsel for the petitioner submits that the petitioner is in custody since 22/11/2025 and has no criminal antecedent as stated in paragraph 14 of the bail application. He has fairly submitted that there is one victim,
Yes, para 68 it is.
one victim could be found out during investigation. The learned counsel for the state has posed the prayer for bail. However, does not dispute that the petitioner has no criminal antecedent and also the custody of the petitioner. To this, counsel for the petitioner has submitted that similarly situated co-accused, namely Santosh Kumar, alias Santosh Kumar Yadav, has been enlarged on bail in bail number 1839 of 2026 by order dated 13/2026. Considering the custody of the petitioner and the fact that similarly situated co-accused has been enlarged on bail, and further that the petitioner has no criminal antecedent, the petitioner is ordered to be enlarged on bail.
Next case में एक antecedent है.
Item 15 BA 1319 of
The learned counsel
2026.
for the petitioner seeks permission to withdraw his bail application. Accordingly, bail application is dismissed.
Sign for the Item 16 BA 1402 of 2026.
Case of cybercrime.
similar same FIR case is listed in today's daily list.
No antecedent. They said two victims out of which other case one victim where no transaction has been done and case one victim of 20,000, around 20,000 transaction has been done.
There is no antecedent, madam.
No antecedent. And one co-accused kind of similar situation has been done.
Right. आपका साइबर लिंक बहुत है, लेकिन साइबर लिंक काफी है, हर स्टेट का है, कई सारे स्टेट्स
But only 2 victims. Only 2 victims. The prosecutor
कोई
has
बात नहीं,
780.
we'll maintain the parity just to take. Organized crime तो नहीं है.
नहीं, ये charge submit for organized crime charge sheet नहीं submit. At page 87 of the case file prosecutor charge sheet का दिया हुआ है. हमें 87.
Or the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner commits that the petition has no criminal antecedent, and during investigation, 2 victims will be identified. He is in custody since
22/12/2025.
he is in custody since 22/12/2025. He has further submitted that one co-accused, namely Tanveer Ansari alias Anand Ansari, has been enlarged on bail by a coordinate bench of this court in BA number 1180/26 by order dated 10/3/2026. The learned counsel for the state, though has opposed the prayer, but the aforesaid submissions are not in dispute. Considering the aforesaid facts and circumstances, and that the co-accused has been enlarged on bail, the petitioner is in custody since 2012/2025 and has no criminal antecedent. The petitioner is directed to be enlarged. इसका कोई co-accused का कब है? 44 है ना, ये केस डायरी उठा के उसमें डाल दीजिए.
Request supplementary say number 3 might be released for Monday. Please get
Item 17 BA1405 of 2026.
no criminal antecedent, but there is one not that way.
Co-accused का रहता है.
Yes.
Counsel for the petitioner submits that the petitioner is in custody since 26/11/2025 and the petitioner has no criminal antecedent. And one victim, and only one victim could be found. He submits that similarly situated co-accused, namely Dinesh Das, has been enlarged on bail by coordinate bench of this court. क्या नाम है इनका?
इनका नाम है निरंजन कुमार दास.
The learned counsel for the state has opposed the prayer.
Only one victim is there.
Case है organized crime.
But blood he has blood कोई correlated नहीं है एक दूसरे से. और he has-
Correlated है.
blood correlated है. Diary में देखिए.
हम डायरी में देख के बता.
Blood he but he has having no criminal antecedent that process. कोई भी similarly conducted that I have seen.
लेकिन
Blood-
please take it
जिसका
that
जिसका जिसका
इसे-
जिसका एंटीसीडेंट है वो जो हमने
modus हम जान रहे, लेकिन हम आपको बता रहे हैं.
yes yes that is
Modus operandi क्या?
modus operandi might use
एक मोबाइल से दूसरे मोबाइल पे मैसेज जा रहा है. They are operating simultaneously. Multiple people are operating simultaneously for committing the same offense.
but
एक विक्टिम के से 4-5 लोग कनेक्टेड हैं.
but for the
ऐसा
mobile
ऐसा आपके इसमें आया है.
might that I have
चलिए इसमें कोई उसको बेल है तो दे देते हैं, लेकिन आई विल टेक वेरी सीरियस व्यू
yes
इन केस ऑफ ऑर्गेनाइज्ड क्राइम.
yes yes blood that I have been this कोई भी उसका एक सीरियल 41 में है उसका एंटीसीडेंट है उसको विड्रॉ कर लेते हैं सीरियल 41 में. Maybe that I am saying before you.
रुक जाइए. Counsel for the petitioner has submitted that the petitioner has no criminal antecedent and only one victim has been found.
Yes.
He is in custody since 26/11/2025. He has also submitted that similarly situated co-accused, namely Dinesh Das, has been enlarged on bail in BA number 1302 of 2026 by the order dated 10/3/2026 by coordinate bench. Counsel for the state has opposed the prayer, but the aforesaid facts are not in dispute. Correct? Considering the aforesaid facts and circumstances, that the petitioner has no criminal antecedent and is in custody since 26/11/2025, and co-accused having been enlarged on bail, the petitioner is directed to bail management.
Same case, serial number 41.
Serial number 41.
Of daily value printed.
Other side one.
Other side, Lord.
उनका appearance record करते हैं. उनका appearance record करते हैं. ठीक है, withdrawal करा दीजिए. उनको बता देंगे. 41 में.
Item 18 DA 1579 of 2026.
Withdrawal for the banana. Give your appearance and put your speed. Next.
Item 19 DA 1611 of 2026.
At the matter, at the request of the petitioner, for this case.
Copies have not been served.
Copies?
Yes, sir.
What copy do you want?
Format copy.
अब दे दीजिए मेरे को copy. Provided during the day.
12/3/2026 का order मेरे को
Yes, why don't you provide? Order था आपको?
Yes, Your Lordship.
Neighbor has committed the offence. कल आ जाइए. You provide in the copy, otherwise I'll adjourn it for another 2 months. Right? आपको दे देंगे copy.
Item 20 BA 1793 of 2026.
petitioner husband शादी के 6 साल के बाद एलिगेशन है कि उनकी वाइफ कुआं में गिर गई थी. एक एलिगेशन इनको सस्पेंशन लगाया कि गला दबा के मारती है उसके बाद कुआं में डाल दिया. पोस्टमार्टम रिपोर्ट आया है जिसमें लिखा हुआ है कि उनको कुआं में जो चोट लगा था उससे गला दबाने का एलिगेशन है. ये जेल में है तो 17/5/2024 मोर देन अबाउट 2 इयर्स. 2 गवाह हुए 11 में से केवल 2 प्रोसेक्यूशन.
We'll expedite your file.
और 17/5/24 2 साल हो गया अभी तक वही गवाह.
आपका सारा गवाह करा दो. BA number 1793 of 2026. For the learned counsels appearing on behalf of the parties, the learned counsel for the petitioner submits that the bail application of the petitioner was earlier withdrawn by the order dated 22/7/2025 in BA number 1812 of 2025. The learned counsel submits that the petitioner is the husband of the deceased and the postmortem report is not supporting the allegation. However, during the course of hearing, it transpired that 2 prosecution witnesses have already been examined out of 11 as on 21/2026. After hearing the learned counsel for the state has opposed the prayer and has submitted that the trial can be expedited. ऊपर custody लिखिएगा 17/5/24. After hearing the learned counsel for the parties and considering the valid allegation made against the petitioner, this court is not inclined to enlarge the petitioner on bail. However, the state is directed to ensure that the witnesses are promptly produced before the court. The learned counsel for the state is directed to communicate this order to the director of prosecution and superintendent of police of the concerned district. 304B में भी हुआ है.
सब ट्रायल में
सारे विटनेस आ जाएंगे, आप चिंता मत करिए.
From the daily list under heading for orders with defect, item 1, BA 21156 of 25 filing number.
ये कहाँ है petitioner? ये डिफेक्ट क्या डिफेक्ट है इसमें? क्या डिफेक्ट? Nobody appears on behalf of the petitioner. However, once for the state is present. However, time till 4th of May is granted to the petitioner to remove the surviving defects eventually.
Item 2, BA 23842 of 2025 filing number.
2 weeks time.
No. Defective? Same order. I am giving you time till 4th of May. It's a preemptive order. And if the defects are removed within time, if the defects are removed within time, post on 6th. दोनों केस में कर दीजिए.
Item 4, BA 29251 of 2025 filing number.
So in this case, only type copy is given and there is a stage of trial. Type copy is of the FIR also, which is quite eligible, that may be removed. And secondly, the stage of trial.
Type copy is
with regard to the FIR also, that is written in handwritten, that's why it is quite eligible.
And what else?
And secondly, the stage of trial. I have checked from this site here also. It is fixed for the argument on the next date, that is 22/4/2026.
तो बेल नहीं होगा ना?
Yes.
22/4/2026.
And so far as merit is concerned, petitioner is custodied for 2 years. And he is being
Argument के लिए स्टेज में बेल नहीं देते. The learned counsel for the petition submits that the defect in connection with typed copy of page 11. The typed copy be ignored for the present, as though it is handwritten, but it is fairly legible. The defect is ignored. So far as the stage of the case is concerned, he has submitted that it is fixed for argument on 22/4/2026. The petitioner is in custody since
17/4/2024.
Since 17/4/2024. He submits that the petition may be enlarged on bail, considering the custody.
Custody, that he has been accused in this case on the basis of suspicion.
And the petitioner has been made accused only on the basis of
suspicion and hearsay.
And
somebody
hearsay,
has said that he has.
And hearsay evidence. Considering the fact that the trial is at the fag end and it is fixed for arguments on 22/4/2026, this court is not inclined to enlarge the petition on bail. However, it is expected that the state would ensure that they would advance their arguments without unnecessary adjournments. That should be sufficient. चल रहा है तो इसका भी जरूरत नहीं.
उसका भी जरूरत नहीं.
चल डिस्कस कंप्लीट.
Item 5, DA 29.
Maybe directed case registered thereafter.
हो जाएगा इसमें तो कोई दिक्कत नहीं.
फाइलिंग
फाइलिंग नंबर से तो
Filing number.
इसमें कुछ है नहीं है.
Item 5, BA 29419 of 2025 filing number.
A directed copy needs to be filed in this case for receipt 2 weeks.
वो जो प्रिंटी ऑर्डर किए हैं वही करेंगे. If the defects are removed within time, then post on 6th of May. 4th May तक आपका प्रिंटी ऑर्डर है to remove the surviving defects.
Under heading for fresh filing, item 6, BA 3100/2026.
Sorry? It's a tied up matter. Withdraw किए थे ना एक जगह?
नहीं वो एक भी विड्रॉ करके
नहीं लाइए ना. Ankit Das. Right?
ABA withdraw.
Oh, ABA withdraw.
The rule attributable to the petitioner matter will find in page number 21.
Cybercrime.
हाँ फादर के साथ ही बात मतलब नीचे से 2 पैराग्राफ मतलब मेरिट में
काउंटर के बिना नहीं करते हैं cybercrime.
तो
Counsel for the state is directed to file counter affidavit along with criminal antecedent report of the petitioner. The office is directed to call for the case diary. किसी में आया है केस डायरी आपके?
हाँ सब लोग को इसमें बेल हो गया है.
कोई बात नहीं. ठीक है केस डायरी आने दीजिए. कौन है इसमें? सैलिन कुमार तिवारी. साइबर क्राइम वाले कोई हैं इधर? Yes, madam, you appear for cybercrime. You inform Mr. Tiwari to file the counter affidavit and antecedent report. I'm calling for the case diary. Post on 6th week. And also the stage of the case. Stage क्या है? कोर्ट से आएगा ना? कोर्ट से सॉरी जहाँ कोर्ट से मंगाने हैं स्टेज ऑफ द केस.
Item 7, BA 3127/2026.
Yes. The alleged offences are under section 103, 238 and 61(2) of the BNS law. Lord, page number 12 is the formal FIR written report. In that, Lord, if I may, Lord, place the role attributed to this petitioner.
देखा दे.
हाँ, जिनके अगेंस्ट स्पेसिफिक है Lord, उनको एंटिसिपेटरी बेल मिला on the ground that.
What do you say, ma'am? General omnibus allegation. Some of the co-accused have been enlarged on the last. Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is a lady aged 25 years. किसी का डेथ नहीं हुआ है ना? Somebody has died?
Yes, 103.
बाकी सबका एंटिसिपेटरी में होगा.
एंटिसिपेटरी ऑन द ग्राउंड लॉर्ड द केस डायरी और हुआ तो उसमें देखा गया कि एलिगेशन जिनके अगेंस्ट स्पेसिफिक था कि रॉड से बहुत मारा गया था बट एक सिंगल ब्रूज पाया गया. दैट हैज बीन रिकॉर्डेड इन द ऑर्डर. Medically not proven the incident.
The learned counsel for the petitioner submits that. The number of co-accused persons have been enlarged on anticipatory bail by a coordinating bench of this court in AB number 6301 of 2025 by order dated 4/2026. And he has referred to the order to submit that the injury report has been considered, the postmortem report has been considered, and in the injury only one bruise was found, and therefore the allegation in the FIR was found to be not matching with the postmortem report. The petitioner is in custody since?
She is in custody from 19 to 2026.
Since 19 to 2026.
Yes.
And has never prayed for anticipatory bail. The learned counsel for the state, though, has opposed the prayer, but the aforesaid submissions are not in dispute. After hearing the learned counsel for the parties and considering the fact that there is general allegation made in the FIR, general and omnibus allegation made in the FIR, and similarly situated coerced persons have been granted anticipatory bail after considering the postmortem report as indicated by the learned counsel for the petitioner. The petition is admitted to be enlarged on that.
Okay.
Item 8, BA 3128 of 2026.
The witness come first line, 8 and 33 arising out of the same.
Yes, इसका जरा स्टेटस बताइए।
The two other cases that I am giving.
3204 का क्या डेट?
अभी नहीं चला है, next date note के लिए।
उसके साथ ही कर देते हैं।
तो उसमें जारी लीक होगा।
उसके साथ कर देते हैं। देखिए इस केस को सीरियल नंबर 33 भी है साथ में।
हाँ, दो केस और है।
कौन सा?
3202 and 3204 वो अभी फ्रेश फाइलिंग में नहीं आया है।
3202 and 32.
Most probably it will come tomorrow.
4.
These two cases.
कोई बात नहीं, इसको पढ़
जो नंबर वहाँ तक आ जाएगा।
ठीक है। 3202 and 3204 दोनों के साथ आज ही ऑर्डर कर देते हैं ना।
तो उसमें वो लिस्ट नहीं हुआ, वो टैग हो जाएगा।
वो टैग हो जाएगा।
ठीक।
इसकी आप चिंता मत करिए।
उसमें को डायरेक्टली कर दिया
हाँ, आप ना जो BA नंबर 3202 और BA नंबर 3204 में जो भी हैं उनको बोलना है कि काउंटर एफिडेविट एंटीसीडेंट रिपोर्ट फाइल कर देंगे। केस डायरी एक केस में मंगा लेते हैं। ठीक है?
हाँ, वही इसी।
Learned counsel for the parties are present. The learned counsel for the petitioner submits that there are total 4 cases arising out of the same FIR. They are BA number 3202 of 26, 3204 of 26, 3128 of 26, and 3199 of 26. The last 2 cases are on board today. And so far as other 2 cases are concerned, they have not yet been listed. Counsel for the state, considering the fact that all these 4 cases arise out of same FIR, let they be tagged and posted on 5th.
चार्जशीट हो जाएगा कि जनवरी का पूरा 2-4 दिन ज़्यादा चार्जशीट नहीं हुआ है।
13th?
Yes.
On 13th of May. The counsel for the state is directed to file counter affidavit and antecedent report of each of the aforesaid bail applications. ऐसा लिखिएगा। Let this case be tagged with कौन सा एक सीरियल नंबर 33 में है?
Yes, 33. That is BA number 3199.
BA number 3199 of 2026, and be posted on 13th of May. Counsel for the state is directed to file counter affidavit and antecedent report, call for CB from the concerned court. So far as BA number 3202 of 26 and 3204 of 26 are concerned, they are directed to be listed tomorrow. Same order कर देंगे?
Yes, yes. On the same day it will be. Yes.
That कर देंगे CB.
I have made a report that the case is that is.
One set of case ID would be sufficient.
Yes.
Item 9, BA 3130 of 2026.
केस डायरी आ गया है। स्टेटमेंट भी आ गया है।
Offense number 96 of the BNS Act. According to FIR, the informant is the daughter of the victim, and the age of the victim as per the certificate by 17 August 10 statement of the victim has been recorded in 180 of the BNS Act.
183 आया है 183 स्टेटमेंट? कहाँ है?
180 का
ये 180 का है 183 का है?
180
उसमें बोली है जो कि हम वहाँ पहुँचे तो वहाँ भी खराब था, बोला गोड्डा बिल्ला चलो, गोड्डा बिल्ला गए, उसके बाद हैदराबाद ले गया, रास्ते में कुछ खिला दिया, लेकिन वहाँ जब हैदराबाद पहुँचे दोनों दोस्त की तरह रहे, जब पता चला कि हुआ रिटर्न बैक हुए, मेरे साथ कोई
दिखाइए 183 का स्टेटमेंट।
यही
रिकवरी हैदराबाद से हुआ।
वही एक ही चीज है कि इनको कुछ खिला दिया
खिला
जाता
दिया,
है,
लेकिन फिर जो हैदराबाद में दोस्त की तरह, हाँ मुझे ये पार्ट लगता है, वहाँ पे दोस्त की तरह है, उसके बाद पता चला तो फिर हम लौट गए।
ये 180 का बयान है ना, 183 का बयान कहाँ है? 183 का तो बयान नहीं है।
183 का स्टेटमेंट
मेडिकल रिपोर्ट हुआ है?
मेडिकल रिपोर्ट हुआ है, मेडिकल में कुछ केस ऑफ द विक्टिम मीटिंग है बता रहे हैं।
ये अप टू डेट केस डायरी है आपका? हाँ? ऐसा तो नहीं लगता है। अप टू डेट केस डायरी तो नहीं है आपका ये। अनुसंधान बंद किया, बस इतना ही है केस डायरी। मेडिकल रिपोर्ट का है, ये भी नहीं लगा हुआ है। It's not there.
मेरे पास तो मेडिकल
और she refused मेडिकल रिपोर्ट। आप कैसे बोल रहे हैं आपके पास?
यहाँ पर डायरी
ये क्या है कि महिला चिकित्सा के समक्ष उपस्थित किया जहां she refused। Office is directed to call for the case diary from the concerned court along with the medical examination report of the victim and her statement recorded under section 183 of the NSS. The learned counsel for the state is directed to file a counter affidavit in this case, post on 6th of May. Counter file करिए।
Item 10 DA.31.33 of 2026.
Tied up। Same कोर्ट में जाएगा।
Item 11 DA.31.34 of 2026.
In this case, the prayer of the petition for grant of regular bail. The offences under section 64, 115.
The state is directed to file counter affidavit in this case, call for case diary along with the statement recorded under section 183, statement of the victim recorded under section 183 BNSS, and also the state of
statement for
state of the case.
स्टेटमेंट फोर्स कौन से ऊपर स्टेटमेंट
183
कोर्ट से ही आता है।
वही कोर्ट ही तो बोल रहे हैं, आपको सिर्फ काउंटर के लिए बोल रहे हैं। CD 183 स्टेट सब कोर्ट से आएगा। पोस्ट ऑन 60 6
Item 12 DA.3136 of 2026.
The counsel for the state to file a counter affidavit, call for the CD from the concerned court along with the postmortem report.
She is asking from the lordship and whatever two grade who accused who have been named in the FIR as granted.
Not without the case diary on the 6th May.
Item 13 DA.3140 of 2026.
बहुत सारा
कब है?
30 तारीख को लगा हुआ लॉर्डशिप BA 2820/2026 में
2820 of 26.
केस डायरी कॉल फॉर हुआ है 30 को।
BA number 3140 of 2026. Post this case, and the counsel for the petition submits that arising out of the same case. BA number 2820 of 26 is listed on 30 2026, in which the case diary has already been called. Counsel for the state is directed to file a counter affidavit and criminal antecedent report of the petition. Post on 30th, tag with BA number 282026. आप चार्ट बना लेंगे भाई, 30 तारीख को बहुत सारे मैटर्स हैं।
नहीं, एक बैच केस में हम एक साइंटिफिक टाइप को बना के जरा
दो चार कॉपी भी रखेंगे क्योंकि पिटिशनर को भी दिखाना पड़ सकता है।
BA 3141 of 2026.
On Monday? शुभ दिन निकालेंगे क्या? And the request of the counsel for the petitioner post this. किसका ऑपरेशन होगा?
नेत्री को हो गया है कैंसर।
Item 15, BA 3142 of 2026.
केस डायरी की जरूरत पड़ेगी ना सर? जरूरत पड़ेगी सर। काउंसिल फॉर द स्टेट इज डायरेक्टेड टू
डैडी की जरूरत है कि इनके हिसाब से
Counsel for the state is directed to file a counter affidavit in this case. Let the case diary be called for from the concerned court.
अच्छा ये हमको एक बार परमिशन दिया था तो 2 लाइन बोलते हैं।
हाँ सर आप बोल सकते हैं 2 लाइन क्या पूरा पढ़ सकते हैं लेकिन बिना केस डायरी के कुछ नहीं करेंगे। हम ऑर्डर हम पार्ट कर चुके हैं।
नहीं सब तक ठीक। ये है तो डायरी मंगाना है।
डायरी तो मंगाना ही।
हाँ तक
ठीक। 6 में
Item 16, BA 3144 of 2026.
This is the second attempt. In the first attempt, when this court was not inclined to give any relief, then it was withdrawn.
क्या करेंगे भाई?
इसमें एक 2 चीजें हैं। At that juncture of time, the charge sheet was yet to be submitted. Charge sheet हो गया है. So my humble
charge sheet कब हुआ? Date of charge sheet.
Yes, right.
Charge sheet कब हुआ?
Charge sheet बता। और जो क्रिमिनल एंटीसीडेंट का जो
15 एंटीसीडेंट है सर।
ठीक डॉसियर है, देख रहे थे, उसमें सब पेपर हम मंगाए हैं, वो भी हम सप्लीमेंट्री करके कोर्ट को देंगे।
Sir, for your kind consideration, antecedent में हम बिल नहीं देते in cyber crime क्योंकि देखिए मतलब just sharing it with you. Now these cyber crimes are punishable up to life also. Serious है और repeat crime में बहुत दिक्कत है। Repeat crime में ऐसा लगता है कि कुछ आदत बन गई है जो जेल में सुधारने की।
Very peculiar things have surfaced in case time. Therefore, I want to bring your lordship's kind attention to that aspect.
Antecedent है कि नहीं? Antecedent है कि नहीं?
Antecedent का भी reply है, वो भी देंगे। हम पूरा papers मंगाए हैं, so I crave leave for producing that, but it will not be problem. Let it be made a part of the report. सारा antecedent को supplementary affidavit में देंगे. In most of the cases, either he is acquitted or he is on bail or charge sheet final report has been submitted. So the English proverb is appropriate. Give a bad name to the dog and kill it. That is what has happened with my client. Peculiar circumstance का ये affair है. I will explain it in detail. If your lordship is kind enough to call for the case diary, I am furnishing the net खुलने से तो तुरंत बता देते net खुल नहीं रहा है. तो एग्जैक्ट डेट बता सकते हैं।
ऑनलाइन फ्रॉड ऑफ 35 लाख ये है कि नहीं?
ऑनलाइन नहीं है।
ये क्या लिखा है? डायरेक्ट एंड स्पेसिफिक एलिगेशन।
आप देखिएगा ऑनलाइन फ्रॉड नहीं। एक आदमी an imposter posing himself to be the higher officials of Jharkhand government sought help from the contractor कि भाई मेरे बेटी गई हुई आसनसोल में उसको पैसा का जरूरत है So 5 लाख रुपया आप दे दीजिएगा उसको. What was the reason for obliging a personal man or posing himself to be officer of the Jharkhand?
Imposter तो थे ना.
Imposter.
एक्चुअली मोबाइल हैक करके भी कॉल किया है. दैट इज वन मेथड ऑफ द साइबर क्राइम. किसी एक आदमी का मोबाइल को हैक कर लिया है और उसके मोबाइल से उसके जो कलीग होते हैं,
आजकल तो आवाज भी हैक होता है. Same to same sound you will find. और उसका एक ही उपाय है.
केस है ही नहीं. My friend is
हमको
वो जो आवाज है हैक होता है ना, उसका एक ही उपाय है. सबको बताने का है.
फेसबुक से
सर एक सेकंड. Not talking about this. जो आवाज जो हैक होता है और जो वो क्लोन होता है, उसका एक ही उपाय है. Ask that person to disconnect and you ring again. That is the only solution. ऐसा आजकल बच्चों को ट्रेनिंग दे रहे हैं, बता रहे बच्चों को. मतलब ऐसा अलार्मिंग स्टेज है साइबर क्राइम. We have to tell them कि मेरा फोन आए तो ऐसे मत मानना. You should disconnect and call me again. बच्चों को बताना पड़ रहा है सर. जो बच्चे बाहर पढ़ रहे हैं उनको बताना पड़ रहा है कि मम्मी का एक्सीडेंट अगर हुआ है, कोई बोल रहा है कुछ, तो डिस्कनेक्ट करके यू शुड रिंग अप. इतना अलार्मिंग स्टेज में बच्चों को इसकी ट्रेनिंग देनी है. सर बहुत सीरियस है, कुछ है नहीं. एंटीसीडेंट में आई नो, एंटीसीडेंट में हम बेल नहीं करते.
ठीक है.
तो रिजेक्ट कर.
ठीक है. My God has opened the mind. I go down before it with all humility. But let me satisfy myself as well as the Honorable Court that what has happened in this case. Your Lordship then applies the mind, and whatever order your Lordship is to pass, I go down. Cash online transaction ही नहीं है. He is not trying to understand.
अच्छा ठीक. आप काउंटर फाइल करिए. ठीक है. Counsel for the state is directed to file counter affidavit and also produce the criminal antecedent report of the petitioner. ऊपर लिखेगा petitioner. The petitioner, the learned counsel for the petitioner has submitted that there has been no transaction of money through
any cyber fraud.
Rather, there has been cash transaction. He submits that this would be apparent from the case diary. Let the case diary be called for from the concerned. Post on 6th May. एक चीज और लिखेंगे. He has submitted that earlier the bail application of the petitioner was withdrawn at the threshold and there was no occasion to call for the case diary.
After a long time, I'm appearing before you.
It's a pleasure always. इसीलिए आपके साथ कुछ शेयर करते हैं क्योंकि you can throw some light on many things which maybe that other juniors may not be able to throw.
Yes. I understand.
And I know,
the weight of this law.
Yes.
I am also to assist the court as well as I am to take
I have
care
highest
of the
regard for you.
society.
You are a pillar to this institution.
So
We have known you for so long time. So that is why many things I share whenever you are there, because you are always there to guide us.
ये आर्गुमेंट सुन के हम लोग कुछ सीखते हैं.
हमेशा जादूगर है हम. इनका नाम जादूगर है.
हर केस में जो खासकर एविडेंस और ट्रायल को डील करते हैं.
सर को ट्रायल कोर्ट का भी बहुत ज़्यादा एक्सपीरियंस है. सो ही नोज एप्रिसिएशन ऑफ एविडेंस में इनकी मास्टरी.
Thank you for the compliment.
और वैसा इनका जूनियर लोग को ट्रेनिंग भी देते हैं.
इसलिए कहा कि हम तो पढ़ेंगे, आपको पढ़ लिए. हम बोले आप क्या पढ़िएगा, हम जिंदगी खपा लिए लिखते लिखते अपना जिंदगी. यही बात है.
अब आप एक इंस्टीट्यूशन खोल दीजिए, बच्चा लोग को ट्रेनिंग दीजिए, वो ज़्यादा जरूरी है. आई एम वेरी सीरियस ऑन दैट. इट इज़ वेरी इम्पोर्टेंट. आप जाते हैं कि नहीं जुडिशियल एकेडमी कभी लेक्चर देने? जुडिशियल एकेडमी में तो आप जजेस को लेक्चर देते हैं ना?
जुडिशियल एकेडमी में of late I have been infected with students, so I am taking extra precaution. आप मेरा वॉइस भी सुन रहे होंगे, चोट लग रहा है. ये सब इनकम्प्लीट 81 ईयर हो गया.
81 को एज होता है सर?
नहीं होता है.
You are the prime age.
So you have.
My parents are 90 plus. They say that we are not old. और उनको
पहले हम लोग सोचते थे कि ओल्ड इज गोल्ड. अब सोसाइटी सोचता है कि ओल्ड इज रोल्ड गोल्ड. ठीक है.
Item 17. Item 17. DA.3146 of 2026.
In this case,
आप कोई क्यों से शुरू करेंगे क्या? अच्छी बात है।
मेडिकल में आया है कि नहीं? FIR is alone. Criminal anticipating.
केस डायरी देख के बेल हुआ था।
Yes,
इसमें केस डायरी कॉल पर हुआ था। ऑर्डर नंबर 3 है, इसे रिपोर्ट नहीं हुआ था ना, मंगा लेंगे। Learned counsel further state is directed to file a counter affidavit in this case. Let the case diary be called for from the concerned court, along with the statement of the victim recorded under section 183 BNSS, and also the injury report. Post on 6th.
Item 18. DA.3147 of 2026.
I am not able to get it. क्या बोल रहे हैं? Victim का एज बताइए. Victim का एज. You read that one. FIR पढ़ी.
No criminal procedure, no medical report.
No medical report.
फाइल 10/6/2024 और डेट ऑफ कंप्लेंट 25 फाइल हुआ था 15/6/24 को। उसके बाद FIR रजिस्टर हुआ 8/11/25 को और कस्टडी है 17/11/25।
आप पढ़िए ना थोड़ा एलिगेशन तो पढ़िए।
FIR पढ़ लेते हैं।
पढ़िए, नाम मत पढ़िएगा, बाकी सब पढ़िए। पढ़िए, रीड इट।
पेज 16 में मैं उपरोक्त मुकदमा को जिला मैं नाना के पासी ग्राम से मंडहार में बचपन से रहते हैं। दिनांक 10/6/2024 मॉनिटर जाने के बाद दोपहर का पर चल रहे प्रेस को लाने गई थी। जैसे 6:30 बजे ऊपर के किनारे पहुंच कर के पकड़ लिया और ये करने लगा तो विरोध करने पर अपने हाथ से मेरा मुंह दबा दिया और मुझे गिरा कर
There is direct allegation against you. I will not grant you. She is just a student of class 6. For the learned counsel appearing on behalf of the parties, the learned counsel for the petition submitted by the petitioner has been falsely integrated in this case and is in custody since 7/11/2024. He has submitted that there is a delay of 5 days in filing the complaint case. The learned counsel for the state has opposed a prayer and has submitted that from the evening order itself, the minor victim, aged 13 years, has supported the allegation under section 180 and also under section 183 of BNSS, considering the direct allegation made against the petitioner. Supported by the statement made by the victim under section 183 BNSS, this court is not inclined to allow the petition on this case.
Item 19. DA.3148 of 2026.
Lordship charge has been framed under section 103(1) of BNS. The Lordship allegation is that he has killed his mother. The Lordship, there is no eyewitness, nor there is any article which has been recovered from him.
Who is the informant of the case?
His sister.
Eyewitness?
No eyewitness.
She is the eyewitness? No. Read that.
Lordship, it has been informed from HCLC that उसका हाथ नहीं है Lordship, and दूसरा हाथ भी वर्क नहीं करता. It has been informed from Jharkhand. FIR निवेदन पूर्वक कहना है कि मैं अपनी देवी उम्र 46 वर्ष, मेरा 2 भाई है, बड़ा भाई मिंजू हेम्ब्रम उम्र करीब 27 वर्ष जो शादीशुदा है, जिसकी पत्नी सुनीता हंसदा,
यस,
छोटा भाई लखन हेम्ब्रम जो तमिलनाडु में काम करता है और एक बहन जो रांची में पढ़ाई करती है। मेरी विधवा माँ पार्वती देवी ग्राम चमरक्को में रहती है। भाई मिंजू हेम्ब्रम, भाभी सुनीता हंसदा, जिला गिरिडीह। मेरी माँ के साथ हमेशा लड़ाई झगड़ा और मारपीट करता रहता था। मेरी माँ को विधवा पेंशन मिलता था जो वो वे पति पत्नी मांगते थे और नहीं देने पर जान से मारने की धमकी देते थे। कल दिनांक 25/5/25 को मेरा भाई मिंजू घर के पास चापानेर का बोरिंग कराया था, जिसको लेकर पैसा मांगने को लेके भी माँ के साथ मारपीट किया गया। जब हम माँ का देखभाल और दवा कराते थे तो वे दोनों हमको बोलते थे कि तुम कितना इसका देखभाल करोगी, एक ना एक दिन इसको जान से मार देंगे। दिनांक 26/5/25 को समय करीब 6 बजे शाम मेरा भाई मिंजू हेम्ब्रम एवं उसकी पत्नी लड़ाई झगड़ा करते हुए शहर से कुछ दूर कार में ले जाकर पटक कर
और the learned counsel submitting on behalf of the parties. The learned counsel for the petition submits that the allegation against the petitioner is that he has killed his mother. However, he submits that the petitioner has been falsely implicated in this case. The counsel for the state has submitted that the sister of the petitioner is the informant of the case and there is direct allegation against the petitioner. After hearing the learned counsel for the parties and considering the direct allegation against the petitioner, who is said to have killed his mother, this court is not inclined to allow the petitioner and this constituted.
Item 20, DA.17.04.2026.
Allegation against the petitioner is under section 69 of 69, section 318 subclause 2, section 351 subclause 2. As per the
in this case, Your Worship, I am appearing on behalf of the informer.
Just a minute. Just a moment. There has been relationship on the pretext of marriage.
Yes.
The victim was minor at any point of time.
But Your Worship, she was also minor and
When was she minor? What is her age? POCSO में register हुआ case?
No. There is a long relation and the relation was from 2019. But Your Lordship, there is the petitioner has a relationship with 2 girls. First, this informant, and second one is namely Roshni. Santoshi Uram. And they
don't take the name, please.
First,
okay. 2 girls के साथ इनका simultaneous relationship.
2 girls.
But still, the victim wanted to marry.
But the petitioner has remarried again with another girl.
When did she marry? When did he marry?
On 3rd, the photograph has come in the diary also.
On which date? After the FIR or before the FIR?
Before the FIR. 3rd January. Because the panchayati was held and in the panchayati the petitioner has admitted that he is ready to marry the informant. And thereafter he has solemnized the marriage with the another girl.
मतलब date का किस बन?
But you notice there are 3 girls involved and 2 were seated by the petitioner.
See, if somebody is establishing relationship on pretext of marriage and the person is a major.
Panchayati was also held.
Panchayati.
In the panchayati he was ready
if
to
a
marry.
person is ready to marry, से क्या होता है? You can't force anybody to marry.
But on
it's a long relationship.
But on pretext of marriage, he has established physical relationship with the informant and one another.
For 6 years, 6 साल तक.
Lordship, he was
because he was always stating that I am constructing the house and after the completion of house I will marry.
Heard the learned counsels appearing on behalf of the parties. The counsel
Lordship,
for the.
he was serving as an Indian army and
आपको समझ नहीं आ रहा है हम क्या सोच रहे हैं? समझ में आता है कि नहीं? कोर्ट को रीड नहीं करिएगा तो बेल कैसे करिएगा? कब से custody? Custody
12/1/26.
12/1/26. For the learned counsels appearing on behalf of the parties, the learned counsel for the petitioner submits that the petitioner is in custody since 12/1/2026 and is serving in Indian Army. And is serving in Indian Army. He has further submitted that, as per the allegation, the petitioner and the informant were in relationship from December 2019, and it is alleged that the relationship was established on the pretext of marriage, and ultimately the petitioner did not marry, in spite of his assurance of marriage during confinement. The learned counsel has submitted that the victim was throughout major, and it appears to be a case of consensual relationship. After hearing the learned counsel for the informant has opposed the prayer and has submitted that the petitioner was having relationship at a time with 3 women, and he has cheated the informant, established physical relationship in the pretext of marriage, and ultimately did not marry the informant and married somebody else.
Para 65 in the case diary, it is not the photograph.
He has submitted that in paragraph 65 of the case diary, this fact has come. The learned counsel for the state has also opposed the prayer. After hearing the learned counsel for the parties and considering the fact that there has been long relationship between the petitioner and the victim for over 6 years, and both being major. The petitioner is directed to be in large way.
Item 21, DA 3155 of 2026.
Offense under section 376 of the
Read the allegation. Where is the FIR? You are named in the FIR? Read. Age of the victim?
25 days. सुनील भेजन के दिनांक 6/5
नाम मत पढ़िएगा, हाँ?
नाम नहीं पता 6/5 के दिनांक शनिवार सुबह का 22 I repeat again, prosecution occurrence took place on 6/5/2023.
Yes.
राठी को जब मैं अपने होटल में पूल में काम कर रही थी तो मेरा होटल का दरवाजा खटखटाया तो मैं सोचा कि कोई खाना खाने करके बुलाया होगा, तो उसी समय गेट खुले तो पति बंधु पिटिशनर लगभग 300 गाँव थाना जिला रामगढ़ में गला पर चाकू रखकर जान मारने के नींद से भय दिखाकर रवाड़ गाँव जबरदस्ती जाकर मेरे साथ शारीरिक संबंध बनाए। मैं दर्द के मारे वो हला नहीं कर सकी क्योंकि वह छुआ गाल को लेकर जान से मार देने की चाहती थी। सही है, जबरदस्ती शारीरिक संबंध बनाने हेतु पति बंधु के विरुद्ध प्रोसेक्यूट कर रही थी।
और कब से कस्टडी में?
Surrender before the court will also on 13 December 2024. Within judicial custody more than 16 months.
13/12/24 से
24.
क्या स्टेज है केस का?
Charge has been filed on clear September 2025, but till date, no prosecution witness has been declared.
आपका एंटिसिपेटरी बेल 23 में ही रिजेक्ट हो गया था, उसके बाद से क्या कर रहे थे?
At that time, I was not the conducting university.
How does that make a difference?
I don't know.
How does that make a difference? 23 में आपका एंटिसिपेटरी बेल रिजेक्ट हो गया, उसके बाद आप टहल रहे हैं, घूम रहे हैं, डायरेक्ट एलिगेशन है और द लर्निंग काउंसिल
It's physical figures from the prayer itself. The occurrence took place on
6/5/22.
But the matter was reported to the police station on 8/5/2023 after the expiry of more than 24 hours. It's crystal clear from the FIR itself.
Please take care. For the learning council. Sorry?
Petitioner has got no criminal antecedent.
Antecedent भी 376 में चाहिए क्या? चोरी डकैती साइबर क्राइम में एंटीसीडेंट खोजते हैं, 376 में एक ही इंसिडेंट काफी है. Heard the learned counsel is appearing on behalf of the parties. The learned counsel for the petition submits that the alleged incident is of 6/5/2023 and the FIR was instituted on 8/5/2023 and there is a delay of more than 24 hours. The petitioner has been falsely implicated in this case and he is in custody since 13/12/2024. However, his anticipatory bail application was rejected by this court on 21st of November 2023. He has submitted that the charge has already been framed on 12/9/2025 and there are altogether 6 charge sheeted witnesses, but no witness has been produced by the prosecution for examination. The learned counsel for the state has opposed the bail and has submitted that on the face of the FIR there is direct allegation against the petitioner. After hearing the learned counsel for the parties and considering the direct allegation made against the petitioner, this court is not inclined to enlarge the petitioner on bail. However, the state is directed to ensure that the witnesses are promptly produced before the court. The counsel for the state is directed to communicate this order to the Director of Prosecution and also to the SP of the concerned district to ensure compliance.
Item 22, BA3157 of 2026.
Annexure 1 at page 10 is the earlier order.
Annexure 1 is just a moment. Tied up now. Annexure 1.
The registry feels that it is not a tied up matter.
What registry feels is not binding on me. I told you on the other day also.
Yeah.
एक केस में कहीं से विड्रॉ करेंगे because they know that the court might not grant bail, फिर दोबारा फाइल करेंगे, फिर दूसरा कोर्ट में जाएगा, वहाँ विड्रॉ करेंगे, फिर तीसरा कोर्ट में जाएगा, जो अपना
time and again these type of matters are listed before the court, therefore I was informing you.
नहीं, I know. Now we have, as a matter of principle, I am passing this order. We have discussed it amongst ourselves also. And जैसे कि हमारा क्रिमिनल अपील में भी टाइड अप मैटर होता है, विड्रॉ करने से सेम कोर्ट में जाता है. अगर वैसे भी कोई सिंप्लिसिटी विड्रॉ कर ले तो भी टाइड अप मैटर मानते हैं. तो बेल में क्यों नहीं मानेंगे? क्या फर्क है आपको? आपको तुरंत ही लग जाएगा केस. कुछ तो मापदंड अपनाना पड़ेगा ना.
Item 23, BA3159 of 2026.
Yes, petitioner. Who are you?
So, and DNA report is awaited because the child go to the victim.
Oh.
The
DNA report is awaited. आप कौन हैं? What is the allegation?
Allegation is cheating on the basis of cheating, having sexual relations with the victim.
What is the age of the victim?
17, as per FIR. There is no conclusive proof of the age.
DNA report of the child is awaited.
Yes, ma'am.
That is why the court is not proceeding.
That is why.
Is that the reason for not proceeding by the court?
In the lower court, I have no information, ma'am, but actually the police has taken sample of the child and still DNA report is awaited. So I request your leadership that should be adjourned until DNA report comes out.
The victim is supported 180 is
yes. You get the DNA report and produce it before that. That should be sufficient. We will not grant him bail, but the DNA report should be produced at the very least. DNA report was collected from where do you say? Because for a child, I think DNA cannot be taken for at least 6 months. When was the child born? When was the child born?
Child born on 17/9/2025.
6 महीना तक सैंपल नहीं लेते हैं. 6 months तक शायद सैंपल नहीं लेते. From where do you say that the DNA report is awaited? Where have you stated that the DNA report is awaited?
IU has informed.
IU ने आपको खबर किया?
हाँ.
Or the learned counsel is appearing on behalf of the parties. The learned counsel for the petitioner has submitted that DNA report from FSL Ranchi is awaited. And appropriate direction is required to be made in that regard. He also submits that the investigating officer of the case has informed the petitioner about this fact. The petitioner is in custody since?
Since 7/10/2025.
Since 7/10/2020. The learned counsel for the state has submitted that the victim has supported the allegation under section 183 BNSS, and she had also become pregnant, and victim was minor at the relevant point of time. So far as DNA report is concerned, the learned counsel for the state has no instructions. As per the interim order itself, the child was born on 17/9/2020. After hearing the learned counsel for the parties and considering the direct allegation made against the petitioner, this court is not inclined to enlarge the petition on bail. However, the state is directed to procure the DNA report from FSL and forward it to the concerned court. The learned counsel for the state is directed to communicate this order to the SP of the concerned district and also to the Director of Prosecution to ensure compliance. That should be sufficient. DNA report aa jayega. So far as the witnesses are concerned, the same we also promptly produced.
Item 24, PA 3160 of 2026.
Simply because the victim stayed at the night one night और मेरा ही फोन हम फोन किए उसके बाद वो अपने पेरेंट्स को फोन की फिर आके देखे.
Where is the FIR?
Page number 69.
Case writing में आ Counsel for the state is directed to file contract with it. Office is directed to call for the case diary along with the medical examination report of the victim, if any, and the statement of the victim recorded under section 183 BNSS. Post on 6th of May.
Item 25, DA 3165 of 2026.
Case diary will be necessary.
Same order.
96 का एक केस है, elopement का केस है.
Same order. 6th May.
Item 26, DA 3167 of 2026.
It's a cyber crime, and so far as co-accused is concerned, in his case, the case diary has been called for. Just
What is the next date? What is the next date in that case?
That case,
BA number किसमें call for the case diary?
BA number 2861-2026. They all were apprehended together.
2861 of 26. Next date का वैसे देखिए.
2861.
2861 of 26. I think these तारीख को वैसे.
No victim, no criminal antecedent, and is in custody since.
These तारीख को. The learned counsel for the petition submits that the case diary has been called for in PA number 2861 of 2026 and is directed, and the said case is directed to be posted on 30/4/2026. Let this case be tagged with BA number 2861 of 26 and posted on 30/4/2026. Also for the state is directed to file contract with it in this case along with criminal antecedent report. बाकी सब केसेस का क्या सिचुएशन है? इसमें देखिए लिस्ट है इसमें, बाकी जितने केसेस हैं सारा कल पोस्ट कर दीजिए, सब एक साथ कर देंगे. ठीक है, पूरा लिस्ट में आप चेक करिए इसको. आपका BA नंबर डालिए और सारा कल पोस्ट कर दीजिए.
Item 27, BA 3169 of 2026.
चलिए केस डायरी काउंटर कितना दिन में मर गई? आप हस्बैंड हैं? सही में केस डायरी जरूरत है?
Because no independent witnesses supported the case.
She died in the matrimonial house within how many days?
The marriage was solemnized.
6/5/25. मर गई कब?
ये बनी हुई कहा जा रहा है कि ये 26/5 3/6/25
तक 1 महीना भी नहीं आप रख सकते।
लेकिन डायरी में अगर देखा जाए
क्या डायरी में क्या देखेंगे हम?
डायरी में एक मतलब कि जो डिसीज की जो हस्बैंड जो फादर है वो भी बोले मतलब कि कभी भी मतलब दहेज के लिए कभी कोई मांग नहीं हुआ, कोई टॉर्चर नहीं हुआ, और इसलिए भी इंडिपेंडेंट विटनेस जो मतलब नेबर है दे स्टेटेड की इन लोगों में कभी झगड़ा झंझट हुआ ही नहीं। और डायरी में ये भी आया कि मतलब डायरी अगर कहा जाए तो उसका कोई रिलेवेंट पॉइंट को उनके सामने पड़ गया। डायरी का पैरा 5 करते हुए लिखिए कि दोनों मिर्जा के पिता वीरेंद्र सिंह और प्रजन सिंह घटना के संबंध में बताएं। बयान दे रहे हैं तो उन्होंने बताया
पोस्टमार्टम रिपोर्ट पढ़िए ना।
पोस्टमार्टम रिपोर्ट है कार्डियो रेस्पिरेटरी फेल्योर ड्यू टू एक्सपेसिया ड्यू टू हैंगिंग। इनकी बेटी फांसी लगा कर रही दहेज के संबंध में पूछने पर उन्होंने बताया कि इनके दामाद और प्रजन के द्वारा दहेज संबंधी कोई मांग नहीं की गई। इनके समाज में दहेज लेने नहीं चलता है। मृतका सुमित ने बताया कि अपनी बेटी का पोस्टमार्टम कराकर वापस आकर थाना में बयान देंगे। उसके बाद ये पैरा 12 जो है
शराब पी के मारता पीटता था तो क्या करेगी लड़की? सुसाइड करेगी ना। यही एलिगेशन। 1 महीना कम नहीं।
डायरी का अगर दीपर देख लिया उसको
क्या देखना है हमको?
इसमें देखना है मेरे को कि इसका कोई रोल ही नहीं है। मतलब व्हेन द ऑफिस वाज गोइंग टू
आपके घर में मरी है
1
महीना के अंदर।
ऑन दैट टाइम मतलब कि
आप ही को एक्सप्लेन करना है।
पिटिशनर वाज नॉट इन द हाउस लॉर्डशिप।
You were not there in your own house.
ये लिखा हुआ है सब कुछ है। एक बार डायरी मंगा कर देख लीजिए।
DA number 3169 of 2026. The petitioner is the husband and his wife
no direct allegation
was found
against the petitioner
and his wife was found dead in matrimonial house within less than 1 month of marriage.
एक बार उसमें डायरी कर मंगा कर देख लीजिए।
The learned counsel for need not be there. The learned counsel for the petitioner submits that his wife had committed suicide by hanging, and there is no allegation of demand of dowry. The learned counsel for the state has opposed the prayer and has submitted that the victim was found dead in a matrimonial house within less than 1 month of marriage, and it is alleged that the petitioner was a drunkard and he used to assault the victim after consuming alcohol. After hearing the learned counsel for the parties and considering the allegations made and the victim having been found dead in matrimonial house within less than 1 month of marriage, and the petitioner being the husband, this court is not inclined to enlarge the petitioner on bail, hence rejected.
Item 28, DA 3173 of 2026.
Just for your assistance, this is a procedural complaint because it falls under the crime against women.
What is wrongly listed?
The sections involved is 341, 323, 324, 307, 379, 448/34.
Woman is not the victim in this case.
No offense against women.
No, woman is not the victim in this case.
No, victim is not Bhikari now. Who is the
Yes, madam.
FIR के लास्ट लाइन में आया है कि तो बेइज्जत करने पर उतारू हो गए और किसी तरह से भागकर
I'm ready to order. It's a case under section 307. Also can look at FIR number.
Let's read that.
FIR page 12. दिनांक 23/9/2020 दिन बुधवार समय करीब 6 बजे शाम को मैं चमन महतो पिता सचिन सच भिखारी यादव पिता सचिन सच चमन रिंकू देवी पति भिखारी यादव सभी का ग्राम थाना देवरी जिला गिरिडीह का निवासी हूँ, जहाँ पर मेरा निवास स्थान है। मेरे जमीन जिसका मुआवजा कालीन थाना देवरी जिसका खाता नंबर 21 प्लॉट नंबर 295 200 रकबा 28.28 डेसिमल में उपरोक्त जमीन पे 2 वर्ष से कायम दखल कर चल रहा हूँ एवं सरकारी का मालगुजारी आवाज करके रसीद प्राप्त करते चला जा रहा हूँ। उपरोक्त खाता में टोला 2.53 डेसिमल है। उपरोक्त जमीन रैयती है एवं कुछ खरीदी है जिसका मैं दखलदार हूँ। दिनांक 23/9/2020 को ग्राम देवत थाना देवरी जिला इतना के petition 1, 2, 3, 4 petition is also named by this case 14-15 the 17% named by the next page सभी का ग्राम तिलैया थाना देवरी जिला गिरिडीह हम राय में हम लोग होके मुदाले हाथ में लोहा का रड लाठी टांगी तलवार से लस होकर हमारे घर में घुसे। मुदाले वासु यादव तलवार से भिखारी यादव के बाएं हाथ में मार
The learned counsel for the state is directed to file a counter affidavit in this case. Call for the case diary along with the statement of the victim recorded under section 183 BNS and also the injury report. It is already communicated to us. Post on 6th. कोई accused का क्या situation लाइव कोई आया नहीं. There is direct allegation against you. We'll see the injury report.
Item 29 DA.17.06 of 2026.
Is registered under section 80 of BNS corresponding section is 4 of IPC sections. Petitioner happens to be the husband of the deceased. The first information report, the written report is at page 13.
The trial is likely to conclude soon.
Well, let's say it is observed in the entry order because 3 of the witnesses have been examined. I am having the deposition, but none of them have supported the case.
We'll expedite it. Or the learned counsel is appearing on behalf of the parties. We'll expedite your trial. कितना बच रहा है please?
According to prosecution witnesses, 3 have been examined, rest 6 have been examined.
Last witness was examined when?
26th of February 2026.
26 to 26.
Next date is.
We'll expedite him. For the learned counsel is appearing.
If I may permit to add one point. In FIR it is alleged that the marriage was solemnized in the month of June.
Who are you? You are the husband?
Yes. And I have informed she has died on 23rd of February 2025.
Marriage is dated?
Date is not there mentioned. Month June of 2024.
June 24. Yes. When did she die?
She died on 23rd of February 2025.
23 to 25. In her matrimonial home?
Yes.
Cause of death?
Well, the cause of death in FIR, it is alleged that she has been strangulated. But there is contradiction in the inquest and post-mortem because there is no such mark injury on the neck. It is alleged that there is a black mark injury on the neck of the deceased. My submission is that there is contradiction in the inquest and post-mortem as such. There is no such neck mark in the black mark on the neck of the deceased.
But how did she die according to you? Because you have to explain she died in your house.
The fact is that this petitioner is drunkard, and there was the dispute was between the deceased and the petitioner. Because of that, she has died.
Heard the learned counsel is appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner has been falsely implicated in this case, although he is the victim, he is the husband of the victim. The marriage was solemnized in the month of June 24, and she was found dead in her matrimonial home on 23 to 2025. The learned counsel submits that as per the FIR, she died of strangulation, but this is not matching with the post-mortem report. He has further submitted that the petitioner was alcoholic and some incident might have happened. Right? The learned counsel for the state has opposed the prayer and has submitted that as per the impugned order dated 17.03.2026 itself, it has been mentioned that the trial is likely to conclude soon. To this, the counsel for the petitioner has submitted that only 3 witnesses have been examined till 26/2/2026.
Next date is on 20th of April.
He submits that next date is on
20th of
24/2026. The counsel for the state has submitted that the witnesses will be promptly produced. After hearing the learned counsel for the parties and considering the fact that the victim died in a matrimonial home within a period less than 1 year of marriage, and there is also an allegation of demand of dowry. The petitioner is the husband. This court is not inclined to enlarge the petition on bail. However, the state is directed to promptly produce the remaining witnesses before the court so that the trial is taken to a logical end. The counsel for the state is directed to communicate this order to the Director of Prosecution and SP of the concerned district.
Some observation may be given
That
with
is
the prosecution as the prosecution witnesses are not being examined.
ऐसा होगा ही नहीं.
I'll renew my.
I put them in contempt because there is a direction for production of witnesses. आपको क्या लग रहा है? ये ऐसा हवा में ऑर्डर होगा? ऐसा नहीं है. If the witnesses do not come, you take the entire order sheet, and come again. Then we book them. Figure it out as to why the witnesses are not coming. Remaining witnesses में 3-4 तो official witnesses होंगे ना. एक डॉक्टर होगा, एक आईओ होगा और inquest witnesses होंगे. यही लोग होंगे.
Item 30 DA3177 of 2026.
For over 4 years and 3 months.
4 years?
Yes, my dear. Only out of 15 charge sheeted witnesses, only 8 have been examined to date. There are no eyewitness of the offence by lady. The petitioner finds no mention in the original FIR.
You have filed the impugned order dated 5/12/25. What happened thereafter?
This case has been assigned from legal aid.
Out of 15 charge sheet, 5 have been examined by prosecution. 8 have been examined.
Case diary.
केस डायरी नहीं होगा ना. ट्रायल चल रहा है अभी. केस डायरी का क्या करेंगे? ट्रायल आपका
जो रिकवर हुआ है इनके घर से रिकवर हुआ है. सेटल में आया.
From the neck of the deceased are same as FSL. FSL report is also supporting the allegation.
Deposition is valid.
Not required. Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petition submits that the petitioner is in custody since
16th of January 2022.
16/1/2022. Until date, the trial has not concluded. She has submitted that out of 15 charge sheeted witnesses, 8 have been examined. She has also submitted that there is no eyewitness to the occurrence. And petitioner is the. How are you related to the victim?
My husband, she was the second wife of my husband. No, sorry, third wife of my husband. First is dead. I am the second wife, and the deceased was the third wife.
Petitioner is the third wife.
Petitioner is the second wife. Deceased was the third wife.
She submits that the deceased was the third wife, and the petitioner is the second wife of Dinesh Chuglu is also an accused.
He's in custody.
He is in custody. The learned counsel for the state has opposed the prayer and has submitted that the wire which was used for commission of the offence resulting in death has been recovered from the house of the petitioner. And as per the impugned order itself, the FSL report has also come, which matches
कन्वेंशनल स्टेटमेंट में आया है.
That's right. The deceased was murdered and dropped in the well after tying from stone by iron wire. After hearing the learned counsel for the parties, this court is of the view that the allegations against the petitioner is very serious and the trial is under progress. However, only 8 out of 15 witnesses have been examined so far, in spite of the fact that the charge was framed as back as on 22/11/2022. In view of the aforesaid facts and circumstances, though this court is not inclined to enlarge the petitioner on bail, however, the state is directed to ensure that the witnesses are promptly produced before the court. The learned counsel for the state is directed to communicate this order to the Director of Prosecution and also to the Superintendent of Police of the concerned district to ensure compliance. Let this order be communicated to the concerned court. इसका non-compliance नहीं आना चाहिए मेरे पास.
Yes.
It should not come. Right? This is a legal aid matter.
Item 31, BA3190/2026.
Cyber matter. No victim matter and no demand. Only 2 mobile was recovered from the petitioner number 1 and 2.
The same order, counter, antecedent. इनका कोई accused है कोई इसमें?
नहीं, 2 है पेंडिंग है लॉर्डशिप लेकिन नो डिफेक्ट.
ये कौन सा है? 319.
इब्राहिम
वो डिफेक्ट में?
और 2 इसी का पीएस केस में है लेकिन डिफेक्ट.
आप फाइल किए?
नहीं हम ये 2 किए हैं सिराज और
State to file counter affidavit along with criminal antecedent report of the petitioner. Call for case diary from the concerned court. 6 तारीख को रख रहे हैं, इसमें चाहिए जाएगा. बताइए किसका किसका फाइल हुआ?
2 का फाइल हुआ जो डिफेक्ट में सकीर का है हुसैन.
सकीर.
BS7615
फाइलिंग नंबर.
इसका जो है ना
7615.
बाकी 2 जो हैं उसका जरा देखिएगा क्या स्टेटस है और लवाजिमा में क्यों नहीं जा रहा.
रिसेंटली फाइल हुआ हम भी चेक किए हैं. ताकि हम लोग भी तो चेक करते हैं ना कोई कुछ कर बिल भाई.
सही बात. लवाजिमा में जाएगा ना?
जी.
लवाजिमा
कोई जरूरी नहीं है. जो डिफेक्ट रिमूव हो जाएगा वो आ जाएगा.
डिफेक्ट अगर रिमूव हो गया होगा तो बेंच में आ जाना चाहिए.
जी हाँ.
ऑटोमेटिक.
डिफेक्ट रिमूव होगा बेंच पे आ जाएगा, मेरा रिमूव हुआ डायरेक्ट आ गया बेंच।
और जिसका रिमूव नहीं होगा वो भी बेंच में आ जाएगा
ना, जो रिमूव नहीं होगा वो वाजमा में जाएगा, वाजमा के बाद 2 बार वाजमा में जाएगा, उसके बाद बेंच पे।
Item 32 DA.3192 of 2026.
The petitioner is for an appropriate order for grant of federal bail from this honorable court in connection with partial ground of jurisdiction case number 79 of 25, registered under section 64, 329 4, 351 2, 351 3, 35 of BS, and section 67 of ITF corresponding to GR case number 768 of 25. Now the case is pending in the court of learned sub-divisional judicial magistrate.
What is the stage of the case?
Evidence validation.
कितने witnesses examined? How many witnesses have been examined? It is an earlier rejected case, no? So that is why I'm asking. How many witnesses have been examined? And the order is also of 10/18/7/25. इतना पुराना order है. From where do you say that how many witnesses have been examined? इसमें कुछ लिखा ही नहीं. There is direct allegation of rape against you, isn't it? Was the learned counsel appearing on behalf of the parties? The counsel for the petition has admitted that the bail application of the petitioner has been rejected by coordinate bench of this court in PA number 7836 of 2025 by the order dated 15/10/2025.
The issue is medical billing violation. The informant has denied for medical.
The learned counsel has submitted that the informant refused to be examined medically, and the petitioner has been falsely implicated in this case. The learned counsel for the state has opposed a prayer and has submitted that the victim had supported the prosecution case under section 183 BNSS, and there is direct allegation against the petitioner of committing rape upon the victim and clicking her obscene photograph and making it viral on public platform. The impugned order is dated 18/7/2025. And the present status of the case is not known to the petitioner as well. However, he submits that evidence is going on. Evidence is going on. After hearing the learned counsel for the parties and considering the fact that bail application of the petitioner was rejected on merits earlier, this court is, and considering the heinous nature of offence, this court is not inclined to enlarge the petition on bail. However, the state is directed to ensure that the witnesses are promptly produced before the court so that the trial is taken to a logical end. The counsel for the state is directed to communicate this order to the director of prosecution and to the superintendent of police of the concerned district to ensure compliance. Communicate. मैडम का नाम दे देंगे, ज्वाइन ऑन करेंगे.
And we're reading for admission. Item 34, BA.10.994 of 2025.
Last meeting, the counsel for the employment was asked to file affidavit with regard to the number of children she is having and the
because there is case counter case between both. They are agnates, and case and counter case of 376 from both sides. She is a married lady. He was asked to file affidavit.
Who was asked? You are.
I was trying for the informant.
He was asked.
The honorable court was asking that how many children the petitioner was having and file affidavit to that effect. 15. But since she could not.
क्या trial तो चल रहा है?
Yes, trial is under.
कितना witness examine हो चुका है? There is the last 10, 12, 25 नहीं. ये तो 10, 12, 25 तो उसके बाद कोई नहीं.
उसके बाद as per my information कल हुआ है कल हुआ है उसके बाद कल हुआ है.
तो slow motion में क्यों चलता है तो?
अंडर 2 years जेल में है. There is 376 का काउंटर केस है दोनों साइड से. ये भी अपना देवर पर किए हैं वो भी अपना देवर पर किए हैं. Under I have annexed for a deposition also.
376 D का केस है.
दोनों साइड से 376 D का केस है मगर कोई दूसरा एक्यूज नहीं है. This scene और इन्वेस्टिगेशन क्लोज कर दिए हैं only against the same person, one person. कहते हैं आए थे 2 आदमी था पिस्तौल लेके मगर कौन 2 आदमी आज तक ना नाम आया ना ट्रैक आया. ये एग्नेट है बगलगीर है पड़ोसी है. दोनों साइड से केस हुआ है 376. उनका एविडेंस भी हम लगा दिए हैं.
आपको क्या एफिडेविट फाइल करना है?
Not the honorable court directed us to file that so how many children the petitioner was the victim was having from his husband. But I called for the foreman but she could not turn up for swearing the affidavit. Therefore I could not file that affidavit.
She is saying that हम स्नान कर लिए कपड़ा धो लिए तब थाना गए केस करने के लिए.
She has supported her case also for the
evidence I have annexed.
Yes.
In the evidence she has supported.
Yes. So much contradiction. I have also if you not then I
false allegation में तो सारा कुछ एकदम परफेक्ट चलता है.
परफेक्ट चलता है दोनों साइड से. I have annexed. अब घर में शौचालय है then she had gone outside early in the morning 4 बजे. 4 बजे जब घर में एडमिट कर दिए शौचालय है और अदर साइड बेनिफिट में है बेल पर है उन पर भी हमारी पत्नी जो है केस किए हैं 376 का डिस्प्यूट है बगलगीर में. They are on bail. The other side is on bail in counter case.
Victim though she is supporting her allegation.
Allegation, but that allegation, but if you appreciate, not only 1-2 paragraph I am. सुलभ शौचालय घर पर है. They even then she is going outside. मुदालय मेरे घर के बाड़ी में कैसे घुसा नहीं जानते हैं. और 4 बजे सवेरे he was waiting along with 2 persons with pistol to ravish her. And he is knowing that she will be coming out 4 बजे भोर में आएंगी और बाहर जाएगी घर में शौचालय में नहीं जाएगी बाहर जाएगी शौच करने के लिए. These are the things.
Whether it was the bathroom was constructed prior to the offence or after the offence has been committed.
और उसका PW2 जो accused है next case में वो कहते हैं कि हम रेप करते देख लिए. And she saying that nobody has हम हल्ला नहीं कर पाए क्योंकि पिस्टल था. और PW2 जो है जो देवर है वो कहते हैं कि हम देखे थे. उसका इनको पकड़ भी लिए और फिर ये भाग गए फिर इनके घर गए. Lord, there are so much of contradictions. Lord, she is a major lady, is married lady. I am saying, Lord. The PW2 is saying different facts. मैं रामजी जहाँ पर गांव के मुखिया सरपंच थे उसके बाद उसके पिताजी आए और उसे लेकर चले गए. Lord, all these things are there.
आपको ट्रायल भी एक्सपीडिट करना सकते. कितने बच रहे हैं? 6 बच रहे हैं. Or the learned counsel's opinion on behalf of the parties. The learned counsel for the petition submits that the petition has been falsely implicated in this case. and there is case and counter case in connection with allegation of rape. He has also submitted that though the case was instituted under section 376D, but charge sheet was submitted only against the petitioner. And so far as other two co-accused persons are concerned, the same were unknown. However, the petitioner has been put to trial and 6 witnesses are remaining to be examined. The learned counsel for the opposite party has opposed a pair and has submitted that the victim has been examined before the court and she has supported the allegation. आपका 83 भी हो गया था?
उसमें एंटीसिपेटरी बिल हम फाइल किए थे, विड्रॉ करके फिर सरेंडर किए, विड्रॉ करके सरेंडर किया। आई एम इन कस्टडी सिंस 19/10/2024।
The petitioner is in custody since 19/10/2024 and the FIR is of the year
2023.
FIR
10/7/2023
is of the year 9/7/2023.
10/7/2023.
And the petitioner was evading his arrest. The learned counsel has submitted that out of the remaining 6 witnesses, most of them must be official witnesses. That's correct? You have no idea.
So far as 2 other witnesses, they are also family members. So far as I remember, because I have seen it.
Official witness / family members.
Yes.
All are the family members.
And the trial can be expedited. He has also submitted that so far as the counter case is concerned, you are on bail.
Yes. I am not the petitioner in that case.
Okay. So it's the last sentence.
My brother-in-law is it.
That's it. After hearing the learned counsel for the parties and considering the fact that there is direct allegation and trial is going on, this court is not inclined to enlarge the petition on bail. However, the state is directed to ensure that the remaining witnesses who are apparently family members of the victim / official witnesses be promptly produced before the court. Counsel for the state is directed to communicate this order to the SP of the concerned district and to the director of the district. Time to ले दे सकते हैं। नहीं आए तो आप प्लीज आ जाइए। Please come. I'm telling you, they will not be able to ignore it. They are under a moral obligation. They are under duty to produce the witnesses.
PW2 is the accused in the counter case. PW2.
We'll see that.
Item 35, DA-1214/7 of 2025.
No, 100 BNS corresponding to the analysis. General omnibus application against out of 782%, 4% have been allowed in external 2 series.
Who are you? मानसो मंडल। कस्टडी बताइए कब से?
कस्टडी है 1925।
1925। It is under 302.
302. 2 आदमी का जो similar dispute, Anju and Manohar Mandal have also been allowed.
They have been allowed bail.
2 आदमी को देंगे सर।
2 आदमी कहाँ हैं?
Case 26-27.
सब लेडीज लोग को बेल मिला।
नहीं, जेंट्स भी है मनोहर मंडल। अंजू एंड मनोहर।
मनसो मंडल।
स्पेसिफिक है
गौरी मंडल पर है लाठी
और
रोशन पर है
खंती से हाथ,
खंती,
ये दोनों पर स्पेसिफिक है।
और पिटिशनर पर
पिटिशनर था जनरल ऑब्जर्वर, मुझे भी मारा जब मेरी बेटी और मुझे बचाने आया तो लोग मारपीट किया, ऑल्दो देयर इज नो इंजरी ऑफ इन्फॉर्मेंट एंड हर्ट।
क्या बोलना
Para 5 witness has specifically alleged that उसी क्रम में मनसू मंडल ने कहा कि यार गिरहानी का जासूसी निकालते हैं और अपने हाथ में ले खंती से मेरे भाई के सर पर फाड़ कर दिया। That has come in para 5 of the witness universe. And other witnesses have said omnibus allegation has been made against all. But in this paragraph, specific allegation is there.
FIR में तो नहीं है ना?
FIR, but informant has not stated.
Informant और उनको हेड इंजरी है? FIR में लेकिन
नहीं,
जो विटनेस है वो आई विटनेस है।
अनफॉर्मेट ये केवल पारा 5 पे ही बोला गया।
कौन बोला? Who has said?
नाम कुसुम देवी।
Heard the learned counsels appearing on behalf of the parties. उसमें तो कुछ आई विटनेस जैसा दिख भी नहीं रहा है।
इसका स्टेटमेंट हम लोग बोल रहे हैं ना, बताया गया ना,
First, this is not clear line.
Heard the learned counsel for the parties. The counsel for the petition submits that the petition is in custody since 1/9/2025 and has been falsely implicated in this case. He has submitted that there is general and omnibus allegation so far as the petitioner is concerned, and the similarly situated persons have been enlarged on bail by the coordinate bench. कौन?
सरिता देवी, किरण
Sarita Devi in BA number 1456 of 25 by order dated 25/25. Kiran Devi in BA number 3053 of 25 by order dated 21/4/25.
Another member, Anju and Manohar.
Anju Devi and Manohar Mandal by order dated 3/12/2025 in BA number 10454 of 2025. The learned counsel for the state has opposed the prayer and has submitted that the witnesses have supported the allegation against the petitioner. However, he has fairly submitted that the said witnesses appear to be hearsay witnesses. Hearsay है? तारावन बताइए।
Para 5. Only para 5. First, he has stated that someone has done it. And another
has referred to paragraph 5 of the case diary. Has referred to paragraph 5 of the case diary.
Yes.
To which the petitioner, counsel for the petition has submitted that the Kusmi Devi, whose statement has been recorded in paragraph 5, is apparently a hearsay witness. After hearing the learned counsel for the parties and considering the fact that there is general allegation against the petitioner and accused having been enlarged on bail, the petitioner is directed to be enlarged on bail.
Item 36, BA 1006 of 2026.
Sorry?
Only not today.
Postmortem. कल हम लोग तो नहीं छुट्टी मना रहे हैं।
कल के लिखा गया है जस्ट मंडे को।
At the request of the counsel for the petitioner, post this case on Monday. क्या चल रहा है आपका? ट्रायल चल रहा है?
Yes, trial.
ट्रायल लास्ट विटनेस बचा है, वो भी 2 तारीख को डेट है, वो आईओ है।
तो क्या के लिए आप सॉरी
The victim has already been examined and the father.
Five
Both the
witnesses.
depositions we have brought on record.
उससे क्या आपका एक विटनेस बच रहा है, आपका ट्रायल तो कंक्लूड होने वाला है, ट्रायल कंक्लूजन पे किसी को बेल देते हैं क्या? कोई कोर्ट नहीं देता।
My senior instructor.
Counsel for the petitioner seeks adjournment. Let the stage of the trial be called for from the concerned. स्टेज मंगा लेते हैं?
Trial see this session. Let the matter be posted on Monday.
आपका स्टेज मंगा लेते हैं ना?
फिर स्टेज आने में टाइम लगेगा
खत्म हो जाएगा।
तब तक खत्म हो जाएगा। जो होगा वो तो मंडे हो जाएगा। ईगो का सीधा चाहिए। इंस्ट्रक्शन के लिए।
Post on Monday.
Item 37 DA1042 of 2026.
Monday. At the request of the petitioner, post this case on
Item
कि मंडे का नहीं है, वेडनेसडे का।
Item 38 DA1060 of 2026.
पास ओवर नहीं होगा, पोस्टमार्टम करना तो कर दीजिए। कहाँ है? कहीं लाए हैं?
नहीं सर, उसको कल
कर दीजिए। At the request of the counsel for the petitioner seeks pass over. Counsel at the request of the counsel for the state, post this case on Wednesday.
Item 39 DA1223 of 2026.
Same case but no criminal antecedent और organized crime में चार्जशीट भी नहीं हुआ। Similarly stated, three co-accused granted bail not by this one. साइबर क्राइम में शायद एक एंटीसीडेंट 498 का ये था वो घर का वही कहता है स्टेटेड हमको लगा कि करती है
तो इसमें
307 का गांव का घर का आपस का ये
कोई एक केस में डेट है क्या इसमें? किसी का
नहीं, लास्ट यही दो केस बचा है।
अच्छा यही दो बचा।
हाँ, बाकी 3 का बेल हो गया है। आई हैव द ऑर्डर।
बेल और कोई एंटीसीडेंट नहीं है।
कोई एंटीसीडेंट साइबर का नहीं है।
साइबर का नहीं।
साइबर का नहीं। 307 गांव का झगड़ा का है, दैट इज वो एक 3 को एक 2 का ऑर्डर दिए हैं, 2 का दिए हैं, एक और का बेल हो गया, 3 का बेल हो गया है। कोई एंटीसीडेंट नहीं है दोनों का।
एक केस करके करते हैं।
Yes.
ये वाला कौन सा है?
संतोष।
संतोष कुमार दास का तो इतना केस देखते हैं।
ये दूसरे संतोष दास का नाम तो बहुत कॉमन नाम है। संतोष दास, संतोष, अरविंद, ये सब तो कॉमन नाम है।
ये नंबर 1023 of 2026. For the learned counsels appearing on behalf of the parties, the counsel for the petition submits that the petitioner is in custody since
5/12/2025
5/12/2025 and has no criminal antecedent
of
cybercrime. He has submitted that there is one case registered against him, which is under section 307 IPC and other analogous cases. So bail हो गया?
ये टोटल वगैरह से या डिस्पोजल हो गया। अगर हम 2 मिनट में हम बता सकते हैं उसको भाई है।
अच्छा है यहाँ?
हाँ, पूछ के।
अच्छा कोई बात नहीं, पूछ के बताइए बेल पर है कि नहीं है, ये तो बताएंगे उस केस में। And he submits on instructions that petitioner has been acquitted in the earlier case. It was a dispute arising amongst the villagers. The learned counsel for the petitioner has submitted that कितना victim है?
कोई victim नहीं है।
No victim has
जिसका
been
victim है उसका
identified.
bail।
No victim has been identified in the present case. आपको क्या मानना? The learned counsel for the state has opposed the prayer, but the aforesaid submissions are not in dispute. However, he has stated that he has no idea about the acquittal of the petitioner in connection with the case registered under section 307 IPC and other analogous cases. After hearing the learned counsel to this, the counsel for the petitioner submits that the other similarly situated persons in connection with whom there was victim also, they have been enlarged on bail by this court in BA number 882 of 2026 by the order dated 26/2/26 and BA number 799 of 2026 by the order dated 26/2/2026.
One more is there.
And
1077
and in BA number 1077
of 9/3/2026.
of 9/3/2026.
In one case, Lord has been dismissed of Balram Das to review after framing of charge.
He has also submitted that with respect to
Balram
Das, the co-accused, the bail application has been dismissed with the liberty to renew after framing of charge. Charge has already been framed.
Not framed as on.
He submits that the charge, itna bolne ka zarurat nahi. After hearing the learned counsel for the parties and considering the fact that he has no criminal antecedent under any cyber offence and no victim as such has been identified and similarly situated co-accused have been enlarged on bail by government benches and custody since 5/12/2015, the petitioner is eligible to be enlarged on bail. और आगे बताइए.
नेक्स्ट केस में वही है, सिर्फ चीज वही है, कोई क्रिमिनल एंटीसीडेंट का तो है भी नहीं.
So next case में
कोई victim भी नहीं.
no antecedent, no victim.
No victim.
Same order.
Same order. खाली वो जो
antecedent नहीं होगा.
नहीं.
वो 307 का antecedent का स्टोरी नहीं है.
बाकी सब सेम.
ये ऑर्डर का कॉपी जो है ना दोनों में जाएगा इसलिए उनको दे दीजिए.
आइटम 40 क्या मतलब?
हाँ 40 है ना, कौन सा 40 है?
39
आप उससे नेक्स्ट केस में हैं, उसमें विक्टिम नहीं है मैडम? विक्टिम नहीं है, एंटीसीडेंट भी नहीं है.
Item 42 BA 1418 of 2026. इसमें ऑर्डर था 47 48 के साथ में.
इसमें काउंटर आ गया. केस डायरी आ गया. Where is the respondent? आपका एंटीसीडेंट
नहीं.
कहाँ लिखे हैं कोई एंटीसीडेंट?
I have stated that RR 70.
इसका कोई उसका बिल देते.
विक्टिम है उसमें.
इसमें तो कोई विक्टिम नहीं है इसीलिए.
इसमें भी है.
गलत सबमिशन तो हुआ ना बेल. इसमें लिखा हुआ है देयर इज नो विक्टिम.
I have case diaries.
तो अब किसी का बेल इसलिए हो गया कि एंटीसीडेंट नहीं है, उसका कोई विक्टिम नहीं है और आप बोल रहे हैं उसका विक्टिम है, तो क्या हम लोग कर सकते हैं?
I have noted in case diary.
I don't want to write that there has been wrong submission. ये तो है आप ही ना.
No victim actually, the victim has not complained any case below. That is
कोई कंप्लेंट लॉन्च नहीं हुआ.
No complaint.
no complaint.
No complaint. That has been submitted.
तो आप बोल रहे हैं कि विक्टिम है उनका?
हाँ victim है, there is a victim.
There is a victim, but
He has not.
not filed any complaint case.
What do you mean? ऑनलाइन पोर्टल पे तो कंप्लेंट होगा ना?
ऑनलाइन पोर्टल
तो फिर विक्टिम कैसे नहीं?
यही तो बात हम बोल रहे हैं।
ये तो गलत है ना? विक्टिम कैसे नहीं है? विक्टिम तो है। And they are supposed to lodge the FIR. They don't do it. There is a complainant. Straight away उसका पैसा गया है।
हम तो बोल ही रहे मेरा भी विक्टिम है, मुझे तो यही सबमिशन केस में है 63 और 66 में विक्टिम है।
The submission is incorrect that there is no victim. What do you mean no victim?
Victim has not come forward to lodge any case. They have not.
Once they lodge the case on online portal, that is as good as an FIR.
That was the query minutes.
You see, the moment is once they lodge a complaint, कैसे किसी को पता चलेगा किसको कहाँ जाके FIR करेंगे? That is a modus operandi which has been devised by the central government. That whenever there is a cyber crime, there are two things which is happening. साइबर क्राइम जैसे हुआ, जैसे ही पोर्टल में रजिस्टर होता है केस, एंड इफ द मनी इज ट्रैप्ड इन एनी बैंक अकाउंट, वो सीज होकर उसको पैसा मिल जाता है, इररेस्पेक्टिव ऑफ द फैक्ट कि कहाँ पर हो वो। आर यू अवेयर ऑफ दिस? आपको होगा साइबर क्राइम तो पता चलेगा, 10-20 लाख रुपए जब अकाउंट से निकलेगा, ऐसे नहीं पता चलेगा। दिस इज व्हाट इज हैपनिंग, द मनी इज बीइंग गिवन टू द विक्टिम। ऐसा नहीं है ना कि ये 10 लाख रुपए चोरी हो गया और ना कोई FIR भी नहीं हुआ। इट इज नॉट लाइक दैट। रजिस्टरिंग द केस इन द पोर्टल बाय इटसेल्फ इज एन FIR, राइट? किसी का 100 रुपए जा सकता है, किसी का 1 करोड़ रुपए जा सकता है, बट दैट इज एन FIR। केस डायरी कहाँ है इसकी? Is it a case of organized crime?
No, Lord, sir.
111 लगा हुआ है इसलिए पूछ रहे हैं।
नहीं, organized crime इसमें
What is the modus operandi? What is the modus operandi?
Yes, Lord, sir.
Bilal Ansari.
Bilal Ansari. No any means of the two persons are involved or anything.
We'll see that. उसका confession statement होगा ना, उसी से पता चलेगा। Modus operandi. आपने इसमें काउंटर फाइल किया? इसमें काउंटर नहीं आया है। बिलाल अंसारी का स्टेटमेंट कहाँ है?
ये 47 है।
इनका 47-48।
अच्छा, ये किसका है? यस मैडम।
Yes, sir. I have received the case diary, paragraph 57 and 55 are the victim's statement here.
पैरा 57 में तो विक्टिम का स्टेटमेंट नहीं है।
विक्टिम है, उसका आया है कि कितना पैसा उनसे ये लोग लिए।
You just read it. Where is it? Where is the statement of the petitioner recorded in the case diary? Where is the statement of the petitioner recorded in the case diary? His confession statement.
Now the case diary is not with me. That is why I'm able to.
No statement.
ये आपको कुछ पता ही नहीं है तो what should I do? Madam, then you file your counter affidavit in this case. I can't do anything about it. आपको कुछ पता ही नहीं है. You are just appearing. You say that you don't have the case diary. Where is the case diary?
नहीं है. I am out of station, that is why it is not taken.
और बाकी दोनों केस इसी में हैं. Rest of the two cases will ask her to file the contract. DA number 1418 of 2026. Counsel for the state is directed to file a contract affidavit in this case, placing on record the incriminating material found against the petitioner. पूरा modus operandi चाहिए, organized crime में हम bail नहीं देते, ठीक है?
Alright.
इसमें मैं अभी यही रखिएगा, केस डायरी से डालेंगे. बाकी दोनों केस
Item 47 and 48.
47 and 48, yes. 1418 case counter has been filed. 1418. He has no antecedent.
47.
1418. No, sorry, 1855.
1855.
Does he have any antecedent?
No criminal antecedent. But there are one victim also.
One victim. Is it a case of organized crime? The case has been registered under section 111 also. His confession statement has been recorded. Bilal Ansari. No, he's Siraj Ansari.
Organized crime.
कहाँ से बोल रहे हो ऑर्गेनाइज्ड क्राइम?
लगा हुआ सेक्शन 11.
सेक्शन छोड़िए, आप हमको मटेरियल बताइए. How are two people and system are connected to each other in commission of the offense? Organized crime में दो आदमी चाहिए ना मिनिमम.
एक दो विक्टिम चीट किया गया है, उसमें दो विक्टिम्स दो एक्यूज मिल के एक विक्टिम.
कहाँ है बताइए?
That is described in the para. para 72 में है वो.
सिराज अंसारी नाम है ना? पढ़िए आप, जो भी आप पढ़ रहे हैं पढ़िए, उसमें तो हमको कुछ नहीं लग रहा है. पैरा 72 बताइए. व्हाट इज द मोडस ऑपरेंडी टू कनेक्ट टू पीपल? 72 में तो चांद मिल जाता है. सिराज अंसारी. सिराज अंसारी इस कांड के प्राथमिक 62 में से कुल 1,05,000 का ठगी किया गया. इस संबंध में पीड़ित द्वारा साइबर पोर्टल पर शिकायत दर्ज की है, जिसका एक्नॉलेजमेंट डिमांड. ऑर्गेनाइज्ड क्राइम का तो इसमें कुछ बात नहीं दिख रहा है. किसी केस में डेमोन्स्ट्रेट करके दिखाएंगे ऐसा एलिगेशन में ऑर्गेनाइज क्राइम लगेगा, तब उनको सोचेंगे क्या करना है, ठीक है। और the learned counsel appearing on behalf of the parties, the learned counsel for the petition submits that the petition has no criminal antecedent and there is only one victim. He has further submitted that co-accused Jan Mirza has been enlarged on bail by coordinate bench of this court in BA number 1572 of 26 by the order dated 1/4/26. He has further submitted that neither learned counsel for the state has opposed the prayer, but the aforesaid submissions are not in dispute. To this, counsel for the petitioner has submitted that the petitioner is in custody since?
In custody since 17/12/25.
17/12/25. After hearing the learned counsel for the parties and considering the custody of the petitioner and that the co-accused, similarly situated co-accused, and that the co-accused having been enlarged on bail, the petitioner is directed to be enlarged on bail. Next बताइए.
Item 48.
Item 48.
Paragraph 64.
48 is Siraj Ansari.
इजहार
Sorry?
इजहार आंसर
दूसरा फाइल लीजिए. इजहार अंसारी. ये सिराज अंसारी का फाइल. Any antecedent?
No. I have stated in
How
paragraph.
many victims are there?
Only one murder. Paragraph 64 of the file. 50,000 का एलिगेशन है.
सेम ऑर्डर कर देंगे. ये हो गया. इसको जो है ना इसके साथ लगा दीजिए जो पेंडिंग है.
जी.
आप बताइए.
42 में भी बस वही है कि जो विक्टिम है और एंटीसीडेंट
पास ओवर किए हैं क्या किए हैं? तो अब प्रिया श्रेष्ठ चली गई, उनको ज्वाइन कराइए. फोन करके ज्वाइन. अननेसेसरी पेंडिंग
सारे का हो गया.
रुक जाइए. मैडम प्रिया श्रेष्ठ को ज्वाइन कराइए. एंटीसीडेंट नहीं है?
नहीं.
क्या नाम है उनका?
बिलाल अंसारी.
बिलाल अंसारी. पैरा 67
दो विक्टिम.
यस मैडम, जिसमें आपको काउंटर एफिडेविट फाइल करने बोले थे उसका 2 को-एक्यूज का भी हम दे दिए हैं. द केस डायरी इज देयर विद मी, राइट. He has no criminal antecedent and there are 2 victims are there. So we are granting him bail. There is no point asking you to file a counter affidavit. Is that correct? So you can same. 2 victims लिखेंगे ना, इससे 2 victims. कस्टडी सेम है सबका?
Item 43 DA 1420 of 2026.
Two other co-accused जिसके भगवान के एक आदमी जिसके खिलाफ में डिटेल्स ऑफ ऑफेंस से पकड़ा गया है.
क्या लेके पकड़ा गया है?
एक मोबाइल. प्लेस ऑफ ऑफेंस से तीनों पकड़े गए हैं. एक आदमी जिसके एक ही के खिलाफ में विक्टिम है उनका भी बेल हो गया है. मेरा कोई
विक्टिम है इनके अगेंस्ट?
नहीं, कोई विक्टिम.
हाँ? कस्टडी?
मिलर कस्टडी है 24/12 2012.
24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 2012. 24/12 20 No victim.
No victim. No antecedent. There is
Co-accused का बेल बताइए.
हाँ, co-accused bail प्लॉट DA नंबर 2041 में नितेश कुमार दास मंडल.
2041 of 26.
नितेश
कुमार
मंडल. एक ही विक्टिम इन्हीं के खिलाफ में आया है, दूसरे के खिलाफ में. एक दूसरा है 1887 of 26 सनम कुमार दास.
1887 of 26.
सनम कुमार दास.
सनम की सनम.
सनम एलियस सोनम. इनके खिलाफ में भी कोई विक्टिम नहीं था.
ऑर्डर है आपके पास?
यस. एक ठोका नितेश का एंटीसीडेंट भी था, मेरा कोई इनका और इन लोगों का कोई एंटीसीडेंट नहीं, कोई विक्टिम नहीं.
Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner has no criminal antecedent and no victim has been identified. He has further submitted that the petitioner is in custody since 24/12/25 and co-accused, namely Sanam Kumar Das, has been enlarged on bail in BA number 1887 of 26 and Nitesh Kumar Mandal has been enlarged on bail in BA number 2041 of 2026 by the order dated 24/3/26 and 16/3/26 respectively. The learned counsel for the state has opposed the prayer, but the aforesaid submissions are not in dispute. नहीं है ना कोई victim?
Yes.
और कोई antecedent भी नहीं है?
नहीं.
Considering the custody of the petitioner and the fact that the co-accused have been enlarged on bail, the petitioner is directed to be enlarged on bail. चलिए ये हो गया. और दूसरा कौन सा है? हो गया.
इस केस में 3 ही एक्यूज था, 2 का बेल.
आपका तो पूरा 100% परफॉर्मेंस हो गया.
3 को रिजेक्ट किया. 3 तो रिजेक्ट.
हो गया सब खत्म. बच्चा है कोई?
बच्चा है 5 के.
मैं कॉल करूँ.
Item 44 BA1452 of 2026.
बताइए कैसे हम आपकी मदद करें, ये बताइए. यस टेल. साइबर क्राइम और एंटीसीडेंट
नहीं लिखे नहीं है. नो एंटीसीडेंट. लेडीशिप ने एक बिल दिया है सीरियल नंबर 16 पे था सप्लीमेंट्री.
सीरियल नंबर
16 पे
मेंशन किए थे कि सीरियल 44
सेम ऑर्डर.
इसमें 2 विक्टिम्स हैं.
2 victims. इसमें 2 victims हैं. नो एंटीसीडेंट. इतना हम बेल देंगे ऐसे सोचे नहीं. लेकिन अच्छी बात.
आज हम लोगों को भी थोड़ा सा आश्चर्य हो रहा है.
आश्चर्य हो रहा है. पॉक्सो में बेल देना मुश्किल है. थोड़ा प्रैक्टिकल होना पड़ता है. ये सब चीज में एंटीसीडेंट आ जाएगा तो दिक्कत है. अदरवाइज कस्टडी
लेडीशिप की बारह बनाया 22/12/2025.
सब एक ही दिन ऑफेंस किए हैं क्या?
हाँ, एक साथ पकड़ा दिया.
एक साथ. को-एक्यूज्ड का बेल
एक आज हुआ है वो
बीए नंबर
1402 of 2020.
1402 of 26.
लुकमान
नाम क्या?
लुकमान अंसारी. सीरियल नंबर 16.
Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner has submitted that the petitioner has been falsely implicated in this case and he is in custody since 22/12/2026. However, during the course of hearing, he submits that the petitioner has no antecedent and as per the allegation, there are 2 victims connecting the petitioner. He has further submitted that the co-accused, namely Lokman Ansari, has been enlarged on bail in BA number 1402 of 26, who is similarly situated. Another co-accused, namely Rajesh Mahra, has been enlarged on bail in BA number 1537 of 2026 by the order dated 11th of March 2026. ये आपको शायद नहीं पता।
वो नहीं पता था, एक और पता था, ये तनवीर अंसारी दूसरा
एक का रिजेक्ट हुआ था, एक का विड्रॉ हुआ
और एक का BA नंबर 1180 का हुआ है
ठीक।
तनवीर अंसारी।
The learned counsel for the state has opposed the prayer. However, the aforesaid submissions are not in dispute, considering the custody of the petitioner and that he has no criminal antecedent, and similarly situated co-accused have been enlarged on bail. The petitioner is directed to be enlarged on bail. आगे बताइए कौन सा और भी आपको तो नहीं।
Item 45 BA 1557 of 2026.
Interpretation under section 96 and 137(2) of BNS. Allegation is that informant says that her daughter was kidnapped and taken away by the petitioner. Subsequently, both of them were recovered. Statement of the victim was recorded under section 180 BNS, in which she has stated that for both of them met for the purpose of marriage. Marriage did not take place, and in her statement under section 180, she clearly says कि कोई गलत काम मेरे साथ नहीं।
Age of the victim.
As per the report, it is being said 16 years. As per medical evidence, it is 17 to 18 years.
Age of the petitioner.
Age of the petitioner is 18 years.
Or the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that though the petitioner is said to be victim, the victim is said to be minor, age 16 years, but during medical examination it was found she was between
17 to 18 years.
17 to 18 years.
The date of birth is also 10/7/2009.
The date of birth has been found to
10/7/2009.
be 10/7/2009.
ये पैरा 70 of the case है।
But the date 16 years here.
16 है।
As per medical evidence, it is 17 to 18 years.
In detail court of health किए हो से।
एक second, look. The learned counsel has submitted that the statement of the victim has been recorded under section 183 BNS, but she has not made any allegation of sexual assault. Rather, she has said that the victim knew the petitioner and he had told her that he would marry her but did not marry. The petitioner is how much? 18 years of age. The Anne is a student. Para 8 में बोलो. The learned and custody since?
Custody since 7/11/2025. Charge sheet has been submitted and charge is also been.
The custody of the petitioner is since 7/11/25 and charge has been framed. The learned counsel for the state has opposed the prayer and has submitted that the date of birth of the victim is 10/7/2009. However, the other submissions are not in dispute. 183 में नहीं बोली है कुछ गलत काम।
और इसमें कि पैरा 14 of the contract में हम दे रहे हैं उसमें मामला चाइल्ड हेल्थ केयर में गया था उसका पैरा इम्पोर्टेंट पैरा है जो टीजर का 25 to 26 टीजर इसमें सारा कुछ डिटेल किए हम ये तो फोर्सफुली जो है भगा के ले।
The learned counsel submits that the petitioner had enticed and taken away the victim. After hearing the learned counsel for the parties and considering the aforesaid facts and circumstances and the age of the petitioner and also the victim, the age of the petitioner and the statement of the victim recorded under section 183 BNS, that that should be sufficient. Aforesaid statement of the victim recorded under section 183 BNS and charge has already been framed. The petition is expected to be enlarged on it. बाकी कल डालेंगे।
जी।